Thank you. Please be seated. Thank you, Ms. Coonan.
Commissioner.
Ms. Kale.
Thank you, Commissioner. Now, Ms. Coonan, I was asking you before the break about the centralised function of marketing within the Crown Group, and I was asking you about those executive positions that appear on the document the organisational chart that the Commission received the day before yesterday. Below the executive level, there is a marketing team, is there, that's physically present at Crown Perth?
There may be one or two, but I'm not sure who they would be or who they are.
Do you know who those people report to?
I think they report through to, sorry, could I just go to the next page?
You're looking at the organisational chart?
The next one. Yes, I think they report through to Mr. Emery.
I see. And Mr. Emery's located in Melbourne, is he?
He is, yes.
Now that marketing team, the one or two people who are in Perth, at some level they have authority to do certain things here without reference to anyone else. Is that right?
I would imagine so, but I'm not sure of the number of them or their identity or what their actual job descriptions would be. In other words, what they're actually doing. But I am aware that Crown Perth does control some of its own marketing in respect of its products and offerings.
Right. So just in terms of that control, does the Crown Perth CEO have any delegated authority in relation to marketing activities?
I believe he would.
Do you know what that delegated authority is?
No.
Do you know who the authority is delegated from?
He would have that authority within his delegations from the CEO, but I can't really tell you with any specificity what the delegations are.
But just to be clear, it's because his reporting line is through to the group CEO that his authority in relation to marketing would come from the CEO. Is that your evidence?
Well, he's got the overall responsibility for the operation as CEO of the property, but my understanding is that people such as marketing people would liaise with and be responsible through to Mr. Emery.
Are there some marketing activities, if they are to be undertaken at Crown Perth in relation to the Perth casino operations, that only the Chief Marketing Officer or a group executive can approve?
You'd have to ask Mr. Bossy that.
Does the Crown Perth CEO have the power of hire or fire over anybody in the Perth marketing team?
I'm sorry, I just didn't hear that.
Does the Crown Perth CEO have the power of hire or fire over anybody in the Perth marketing team?
I would think he would. I mean, he'd be responsible for who is hired and who is working on the property.
So he hires the marketing team?
I don't know.
What involvement does the Burswood Limited Board have in overseeing Crown Perth's marketing activities?
I'm not aware of any, but I've only been there a very short time.
So you're not sure whether Burswood Limited Board has any responsibility or power to oversee the strategic direction of marketing activities in respect of the Perth Casino?
Well, they're operational matters, and Burswood Limited or the Burswood Group obviously have got oversight over the operations. But as I explained earlier today, there are some functions which have got centralised features, so it is quite possible that people who do marketing would do it by arrangement with and liaison with the Chief Marketing Officer.
Now, is it possible for the Burswood Limited Board to say in terms, well, we don't like the Chief Marketing Officer's direction, we don't like the Crown Group marketing strategy or activities, we want Perth Casino to have a different strategy or undertake different activities? Is that possible?
Certainly they'd be welcome to have that view if they came to it.
But can they override the group marketing strategy or activities?
I'd have to know what was being suggested here, what sort of example, to try to give you some greater precision in my answer.
So does that mean there might be circumstances in which, in effect, the Burswood Limited Board doesn't have a power of veto over marketing strategies of Crown Group, but there might be other occasions where it does?
Well, as I explained, with centralised functions, there is if you like, a dual role where the overall strategic direction is set by the parent, and then the local subsidiaries have got oversight in terms of implementation. So it would depend on what their objection would be. I'm sure they'd be listened to very carefully, and if warranted, action would be taken.
Now,
It would depend where it arose and with respect to what.
Can I take you back to the organisational chart, Ms. Coonan? And I'm on the page headed Perth Executive Team. Do you have that?
Yes, I've got that now.
Now, you can see that on the left-hand side of the page, the farthest left-hand line of reporting, there's some what one might assume are local Perth positions in relation to gaming machine operation, and then to the right of that, table games. Do you see that?
Yes, I see that.
And then on the far right-hand side, you'll see two shaded boxes with Mr. Herring and Mr. Christie's name in them. Do you see those?
Yeah, yes, now I do.
Yeah. And those two positions are Melbourne-based, aren't they? That's what it says on the box, in the boxes.
Yes, I think so.
Yeah. Now, these two men are Group General Managers, it says, for Product Strategy Innovation in relation to gaming machines and table games. Those are group positions.
That's what it says.
Yeah. With only a dotted line report to the CEO of Crown Perth, but a direct report to the CEO of Crown Melbourne. Is that right?
I don't know it. Could I just have it shrunk a bit, please? I can't see the dotted line. Okay. Yes, I'm not familiar with this, so I'm sorry I can't. I'm just looking at it now. Yes, that appears to be correct.
So why do they report to Crown Melbourne CEO?
It's obviously a group role with group functions across the two properties.
But then they should report to the group CEO, shouldn't they?
I'm sorry, which group CEO?
The CRL group CEO.
Well, it says they report to Steve McCann, CEO and MD of Crown Resorts.
You see, it says Peter Herring. We'll just take that one.
Yeah.
Do you see the blue type?
Yes.
Reports to Xavier Walsh, CEO, Crown Melbourne.
Yes.
So that's a local Melbourne position.
That is, and a dotted line to Mr. Bossy, who's his equivalent in Perth.
I see. So the dotted line reports to Melbourne and Perth.
That's my understanding.
Yeah. And who do they directly report to? What's the solid line report?
The solid line report, both of them report to the CEO, who's about to be Mr. McCann.
All right. Now, Mr. Sullivan reports to Mr. Herring and Mr. Christie.
Yes, I think so.
Does he have any dotted line report to Mr. Bossy?
Well, not on the chart.
But what in
But my
practice?
understanding is that he does.
And what's that?
Because he's based in Perth, I think.
And if he's based on Perth, there's a dotted line report to Mr. Bossy. Is that what you assume?
Not necessarily, but my understanding is that with respect to Mr. Sullivan's responsibilities, that he also has a dotted line to Mr. Bossy. I could be wrong about that.
So essentially, are Mr. Herring and Mr. Christie responsible for strategy for product development and business development in relation to table games and gaming machines at Crown Perth?
I think that's part of their roles, yes.
And does the
But I'm not entirely sure. This is deep in management for me, and I'm effectively a non-executive director of the parent. So unfortunately, I don't have this familiarity to be able to provide accurate answers to the extent that I would otherwise like.
Well, does the Burswood Limited Board have any governance or oversight of Mr. Herring's and Mr. Christie's function?
They would in terms of what happens locally, but not in terms of what happens in Melbourne.
Can the Burswood Limited Board depart from the Crown Group gaming machine or table games product strategy?
Could you say that again, please?
Can the Burswood Limited Board depart from the Crown Group gaming machine or table games product strategy?
They possibly could, particularly if there's some regulatory impediments or issues locally in Perth.
Well, let's take an example, Ms. Coonan. In the absence of any regulatory requirement, if the Burswood Limited Board decided they wanted to have in the Perth casino only EGMs that had fewer addictive features than the machines the group function was purchasing, would they have the ability to pursue that strategy?
It's a total hypothetical, Ms. Carl, I don't know.
The actual day-to-day operation of gaming machines and table games at the Perth Casino is controlled at the local level, isn't it?
It is.
What is the rationale for the division of responsibilities between the product innovation strategy being located in as a group function and the day-to-day operations as a local function?
Probably historical, I would have thought. But I'm not in management, Ms. Carl. I can't help you with that detail.
You appreciate, of course, don't you, that it's Crown Perth or Burswood Nominees Limited and not CRL that's been granted a licence by the state of Western Australia to conduct gaming operations in this state?
Yes, I keenly appreciate that.
Has the board of CRL during your tenure ever discussed and considered whether it is appropriate for someone other than the licensee to have control over the strategy and development of gaming operations at Perth Casino in the way in which this group function does?
Well, first of all, I don't accept that the group function does that, and I can't recall a discussion about it. I don't recall it having been an issue.
Now, there's no ICB business in the Crown Group at the moment, is there?
I'm sorry, could you just say that again? There's no what?
ICB, International Commission Business.
No, that's true.
Now, you mention at 116 of your witness statement that Crown Group has resolved to permanently cease junket operations.
Yes, that's true.
What do you mean by permanent in that context, Ms. Coonan?
Not doing it in future.
Because the Board of CRL could, of course, at some later time, however constituted, resolve to recommence the ICB business, couldn't it?
Well, it couldn't if there's regulatory impediments to it, which there currently is in Perth. In New South Wales, I understand there may be legislation to that effect. I can't speak to it in Melbourne, but the board is of a view and has come to a view that they have no intention of recommencing that business.
Now, prior to the cessation of the junket and premium player business by the Crown Group, the development and management of that business in relation to Perth Casino was effectively controlled outside of Perth. Is that so?
Yes, that's right. That's my understanding.
And was it essentially controlled by the Crown Group or Crown Melbourne?
It was controlled largely by Crown Melbourne, or out of Crown Melbourne, and by the VIP group.
Who answered to whom? The Crown Melbourne board or the CRL board?
Both.
the Burswood Limited Board had no oversight or governance of the operation of the ICB business insofar as it involved the Perth Casino, did it?
They hosted junkets in Perth. That's my understanding, but I'm not sure about what oversight there may have been.
The Burswood...
Basically, but your point, which is correct, is that it was basically more a Melbourne function.
The Burswood Limited Board did not have the ability to independently of CRL or Crown Melbourne control whether junkets came to Perth, and if so, on what terms. Is that right?
I don't know, but I don't think they ever did.
Again, having regard to the fact that neither CRL nor Crown Melbourne is the licensee of Perth Casino, did the Board of CRL during your tenure ever discuss or consider whether it was appropriate for someone other than the licensee to have control over the ICB business involving Perth Casino?
I don't recall a discussion of that kind.
Moving to AML CTF issues, Ms Coonan, at 122 of your witness statement, you explain that the Crown Group has a centralised AML CTF system and set of policies, procedures and controls. And you mentioned, by cross-referencing to your evidence in the Bergen inquiry, about Crown Group having promulgated a joint AML CTF program across the properties as well as a corporate policy statement. You recall that evidence?
Yes.
Previously, it was the case, wasn't it, that each property had its own compliance program for AML CTF issues?
That's correct.
Right. And the new program, the joint program, has been adopted by the CRL board, hasn't it?
Yes, and each of the subsidiary boards.
Now, it's going to be my next question. Burswood Limited has resolved to support the adoption of that program.
Yeah.
Yeah. But, sorry, I'll be clear about that. Burswood nominees, you say at 125,
Yes,
has
that's
resolved
correct.
to support the adoption
Yes.
of that joint program. And you understand that Burswood nominees is exclusively an executive or management board, or was at the time?
Yes.
Yeah. And has the approval of Burswood Limited Board been sought in relation to the joint AML CTF program and corporate policy statement?
Yes, it was approved at a Burswood Limited meeting.
And does Burswood Limited Board now have any responsibility in relation to the oversight or governance of that joint program?
Yes, they would have oversight of the local parts of the program, but it's a group program. The joint AML CTF program is a joint program with each of the properties being part of the designated business group as part of the adoption of Part A, I think back on the 2nd of November last year. And the reason for the joint program largely arose out of recommendations from Mr. Neil Jeans of Initialism back in 2019. He attended the CRL board, and his evidence was that manual systems and standalone systems, siloed programs, gave rise to vulnerabilities. And to better align the AML function, it should be a joint program.
Now, at 126, I think you're referring there to this 2nd November meeting that you mentioned a moment ago. We can see 126 clearly, please.
Yes.
Thank you. Now, you say in the second sentence, at the same meeting, which was a joint meeting of the boards of CRL and the property entities, can you just explain what you mean by the property entities?
Yes, Sydney, Melbourne and Perth.
But do you mean to include Burswood Limited in that description?
Yes. But Burswood nominees as the licence holder.
Did the Burswood Limited Board have any input into the development of the joint program and policy statement as it stands today?
Well, I haven't been on the Burswood board for very long. Certainly, I was there at the point at which it was adopted, and there were questions of Mr. Blackburn, who presented at that meeting, and and acceptance of the program. So I'm not sure whether prior to my involvement with Burswood, there was consultation at that level.
Now, if we go to paragraph 130 to 132 at page 0201 of your witness statement. You see there in 130, you're describing what part A of the joint program entails.
Yes.
And then at 131, you say under the joint program, in addition to the obligations of the CRL board and senior management, you describe responsibilities of the board of Burswood nominees.
Yes.
See that?
Yes.
Now, where does Burswood Limited fit into all of this?
Oh, well, Burswood Limited holds meetings. That's what I meant. Burswood Limited actually holds the meetings at which these functions are exercised for Burswood nominees.
Could you just say that again, please?
Yes, Burswood Limited, it's a consolidated group here. Burswood Limited's meetings also include obligations relating to Burswood nominees and Burswood management. So that's what I meant.
So at 132, material AML CTF matters must be escalated to the board of Burswood nominees.
Yes.
Should that read Burswood Limited, or should there be an additional sentence that goes along the lines of, and then escalated from the board of Burswood Nominees Limited to Burswood Limited?
Well, that's my understanding about how it operates in fact, but the obligation actually sits with Burswood nominees as the member of the designated group.
So if we have a look at 133, please. You nominate Burswood nominees again here as having adopted the 3 lines of defence.
Yep.
And if we look at the first line of defence, that's you reference their operational management. This is effectively the people on the ground who are actually performing the operational roles at Crown Perth are the first line of defence to identify and manage AML CTF risk. Is that right?
Yes, correct.
And then the second line of defence, you reference the financial crime and compliance teams. That's a group function, is it?
2 group functions. One is risk, headed by Ms. Seekers, and the financial crime, and so risk is one of the second lines of defence. The other is the financial crime and compliance team, headed by Mr. Blackburn.
Now, in relation to that second line of defence, is there any involvement by the local Perth executive team, the Burswood Nominees Limited board, or the Burswood Limited board in that defence?
Only in terms of reporting to them, I would think. For example, if there's some issue involving AML that arises in the Perth operations, that would be a report to the financial crime and compliance teams. It's a group function.
All right. Now, just while we're talking about AML, if we go back to the organisational chart that I had you at before, Ms. Coonan, that's PCRC 0004, 0007, 0003, and the next page, please, Perth Group Executive Team. Do you see at the bottom to the right Mr. Stokes' role, Group GM AML?
Yes.
Is that role the most senior role in the second line of defence?
No, it's Mr. Blackburn.
All right. Is it the second most senior role?
There've been about another 16 hires over the last few weeks, so I'm not sure, but I would think so because he's a he has to be approved under the program. So he really is the group, he has that role for AML.
All right. And is there a person who is identified as a replacement for him when he leaves at the end of September?
Yes, I just can't recall her name, but there has been a hire.
Right. Now, just coming back to paragraph 133, going through those lines of defence, we're now at the third line of defence you describe as the internal audit function. We can just show Ms Coonan her witness statement, please. See, the third line of defence provides independent assurance, etc., and consists of the internal audit function. You've got that?
Yes, that's Miss Ottner, Jessica Ottner.
So that's the Chief Risk Officer, is it?
No, she's audit, internal audit.
Yes.
No, Miss Seegers is the Chief Risk Officer.
All right, so there's an internal audit officer.
Yes, that's right. As part of our structural reforms, we separated risk and audit to provide an extra line of assurance. And so the third line is a new function, or at least a function now headed up by a new person, Miss Ottner, Jessica Ottner.
Now, does the local ERCC retain any role in respect of the internal audit function?
The local ERC, this is deep in management. I will do my best to provide an accurate answer here, but they interrelate. So Mr Blackburn and Miss Seegers, and I understand Ms Ottner, all sit on the ERCC. So there is a line there.
But does the ERCC oversee the internal audit function?
Not that no, I think that's independent of the ERCC. So
as far as you're aware, and accepting that you're not, as I understand, you're saying you're not completely sure of this, but your best...
Well, I'm not in management, so I can't. This is Mr Blackburn's area. He has administration of this program. And I may not be doing him justice, but I'm trying very hard to give you accurate answers.
Thank you. But is it your best sense of it, with all those caveats, that the ERCC oversees risk management and compliance, but not the internal audit function?
I don't know.
Are you aware of the composition of the ERCC in Perth these days?
Yes, I did see a list, but you'd have to take me to it.
Well, let's have a look at a recent agenda paper which will identify the attendees. CRW.700.019.0001 is the agenda for the ERCC meeting for 19 May 2021. And if we blow up the attendees, please. Now, if we take Mr Murray out of the equation as an executive officer and not a member, we have Mr Bossy, who's local, a local Perth person. Yes?
Yes, he's in Perth, and so is Mr Murray.
Yes. Mr Hill. Local?
I think he is. I don't know that I've met him.
Mr Kukan?
Yes, he's I understood he may have left.
Yeah. And Mr Cairns is, he's actually, that's a group position, isn't he, Mr Cairns?
I don't know. I'm not in management.
Well, if we have a look at the organisational chart with the Perth executive team written on it, and almost...
Yes, I can see Mr Hill's name.
Yeah. And it says he's the Executive General Manager of Crown Hotels Perth, apparently reports to somebody in Sydney.
Are we looking at Mr Hill?
Cairns.
Oh, sorry. I don't... Oh.
See that?
Yes, I can see that, and also Mr. Bossy.
Yeah. Dotted line to Mr. Bossy.
Hmm.
So why does Mr. Cairns report to Sydney?
Obviously, his duties require both sites, or some attention to both sites, but his title is obviously Perth.
Now, if we go back to
I don't know this, but there were some realignments with respect to getting Crown Sydney open, but it may not be a permanent.
Right, if we go back to the agenda paper, please, CRW 700-019-0001. And looking at the attendees blown up for Ms. Coonan, please. Apart from the ones I've identified, the other positions are group positions, is that right?
I think that's probably right without going through each of them, but I think so.
What's the rationale for having a number of group positions on the local ERCC?
Because their functions obviously have some relationship to the operational matters in Perth.
Is there scope for the Burswood Limited Board to decide that Burswood Nominees Limited should not be part of the joint AML-CTF program and to have instead have its own AML-CTF compliance program for regulatory purposes?
Could you just break that up a bit, please? I lost you there.
Sorry. Is there scope for the Burswood Limited Board to decide that Burswood nominees should not be part of the joint AML-CTF program and to instead have its own AML-CTF compliance program for regulatory purposes?
It would not do that based on expert advice.
Would CRL Board permit that?
Well, CRL Board would take advice about this, and in particular from Mr. Blackburn, who's a well-known expert who has put in place a group AML CTF function to provide the best possible AML CTF compliance system that we can devise. It's been rolling out now for some months, and we accept the advice that the function, this ought to be a group function, to be better aligned and to provide better systems and better preventions against money laundering.
The effect of that analysis that you've just given is that the CRL Board would be likely to not permit the Burswood Limited Board to depart from the joint AML CTF compliance program.
I can't imagine any reason why they should depart from a joint program that provides efficiencies, better alignment, better automation, better expertise than a siloed AML function which was criticised in the past.
So if we can come back to the organisational chart, please, on the page that's headed Perth Group Executive Team, and we come back to the Group GM AML position at the bottom, currently occupied by Mr. Stokes. So that's a Melbourne-based position. Is there any position immediately under that, a senior management position located in Perth in respect of AML?
There may be. There are now, I think, something in the order of 54, I think, people who have been hired into the AML function. Some are based in Perth, but this is a function that can be, it's largely automated. A lot of it is automated. It's not particularly relevant where you physically sit, but there are some located in Perth. I can't give you the exact number.
Now, I want to ask you about risk management more generally, not just AML risk, Ms. Coonan. And this takes us to paragraphs 80 to 98 of your witness statement at pages 0193 through to 0197. Do I understand correctly from paragraph 81 of your witness statement that the risk appetite for the Crown Group is set by the CRL Board?
Yes.
Sorry, was that a yes?
Yes.
Yep.
But each property has its own risk profile.
Well, does the Burswood Limited Board or the Burswood Nominees Limited Board have any control or influence over how the risk appetite is set for Perth Casino?
Yes, they provide their own risk profile and feedback to to Ms. Seegers and the Risk Management Committee.
But can they control how the risk appetite is set for Perth Casino?
The risk appetite is set for the group.
And can the Burswood Nominees Board or the Burswood Limited Board control or influence that risk appetite insofar as it applies to the Perth Casino?
You'd have to take me to what it is that you're suggesting would be changed from our current risk appetite to give me a clue as to what might need to be changed.
The risk management strategy and risk management policy that you refer to at 81 is approved by the CRL board, isn't it?
Yes, it is, yes.
Is it required to be approved by the Burswood Limited Board insofar as it affects the risk management strategy and policy specifically for the Perth Casino operations?
It's a general overarching risk management appetite that is set by the CRL board. It's not altered by any of the subsidiaries, but each of them do have a role to set their own corporate risk profile.
Is this risk management strategy that you refer to at 81 and the risk management policy required to be approved by the Burswood Limited Board before it is implemented in respect of Perth Casino operations?
I believe it is approved.
Is it required to be approved before it is implemented in respect of the Perth Casino operations?
I don't know. I mean, I wasn't on the Burswood group when this was settled.
If we go to paragraph 85, please, at page 0194, you refer again to the 3 lines of defence in respect of the risk management strategy, which mirrors the evidence you gave earlier in your witness statement in relation to the management of AML risk, which we've already discussed. Is that right?
Yes, that's true.
And so, again, you've got the first line of defence all occurring on the ground at local operational level.
Yes.
And then the second line of defence refers to an independent risk management team, which is a group role, is it?
No, that's the reference to the risk management. That's a reference to Ms. Seegers and her team, and the compliance and AML functions of Mr. Blackburn's team.
Right. Now, if we just come back to the risk management policy...
Would you like me to explain what independent means?
If you'd like to explain, go ahead.
No, I'm just wondering if you're interested. Basically, with the restructure that we went through last year, we separated out, as I explained a little earlier, risk and audit, and the risk management team now reports directly to the Risk Management Committee. They are separate, as is compliance and the AML functions, from any of the operational arms of the business. So that's what is meant by independent. And Mr. Blackburn actually reports directly to the CRL board. And Ms. Seeger's team reports to the Risk Management Committee and to the board.
But what about to the Burswood Limited Board?
Yes, they report to the Burswood Limited Board as well.
Who can basically direct them in relation to the second line of defence, insofar as it relates to Perth Casino?
Well, they would certainly have some input into issues if they know of them. That's what this is designed to do, is to enable local matters to do with risk and local matters to do, for example, with AML, to be escalated through these functions. And so obviously Burswood Limited has an oversight role as well.
If I can just take you quickly to the Crown Resorts Limited Risk Management Policy, CRW.512.043.0051. And if we go to page 0053, please, and focus in on section 2, risk management at operating level. The second paragraph there is talking about each Crown business being responsible for maintaining and reviewing the risk profile of its business.
Yeah.
So that's management of Crown Perth.
Sorry, that's what I was referring to.
But it goes on. Sorry, you finish.
Sorry, I was just saying that was what I was alluding to in my earlier answers.
Right. It goes on to say, and shall be responsible for reporting any material changes to the Crown Risk Management Committee at least 4 times a year.
Yes.
But it doesn't mention the Burswood Limited Board or Burswood Nominees Limited Board. There's no requirement to report into them any material change.
I think it's subsumed into each Crown business because, in fact, at the last Burswood meeting that I was at, there was a very, very detailed risk meeting presented by Ms Segers and an upgrading of the risk profile of Crown Perth.
All right, so if we go over the page to section 4, and we're looking at the obligation under 4.1 for each Crown business to identify, assess and manage material risks. Should we read that reference to each Crown business as being the, in this case, Crown Perth management as overseen by Burswood Limited Board and Burswood Nominees Limited Board?
Well, that's what in fact happened, yes.
That's how we should understand the policies intended to operate.
In fact, that's what happens. As I say, at the last Burswood Limited meeting I was at, this is exactly what happened.
And I understand from the evidence that you've given about risk management that you're firmly of the view that it is better to have an overarching group risk management strategy than to allow the local operation overseen by Burswood Limited Board to set its own separate and individual risk management strategy.
Yes, I think that would be a backward step because a central risk function that's separate from the operating arms of the business is independent, is not beholden to any other operational part of the business and can set the overall strategy. That's not to say that there aren't issues to do with local business and local governance, that is the subsidiaries and the subsidiary boards, for having an overview about identifying, assessing and managing their own risks. So it goes both ways is really the best way to describe it. And I think that's the most effective model.
And does that model take account of the fact that the licensee, rather than the Crown Group or the risk management group that it has established, it's the licensee that has responsibilities to the state of Western Australia for the operation of the Perth Casino and the risks that creates?
Well, that's part of the risks that are assessed in the local corporate profile. Obviously, maintaining your licence is a critical risk, or any threat to maintaining your licence is a critical risk.
Can I ask you about harm minimisation now, please, Ms Coonan? You speak about that in your witness statement between paragraphs 174 and 192. And at 175, you describe how the policies and procedures for responsible service of gaming apply across the whole Crown Group.
Yes.
At 178, you explain there that the policies, as I say, are set across the whole group, but implementation occurs at a local level.
Yes.
Now, in terms of the setting of the policies and procedures, does either the CEO of Crown Perth or the responsible gaming team members in Perth have any input into the establishment of those policies and procedures?
Yes, well, they have. Traditionally. This, of course, is a very important area, a very important part of our social licence to operate, and one where some consistency across the Crown properties is very important, particularly as you have visitors coming from different properties. And so the idea of having centrally formulated responsible gaming policies, I think, works well. That's not to say that there aren't some particular needs at property level, and that's been there've recently been some examples of that where, as part of our expert advisory group, there've been some specific recommendations in respect of Perth, but not Melbourne, that have been implemented. So it's a matter of understanding what is needed locally, as well as understanding what it is about the group function that can deliver this very important service in a consistent and efficient way.
So does the Burswood Limited Board or the Burswood Nominees Limited Board have any capacity to depart from the Crown Group RSG strategy and framework?
If there was some reason to, it would be interesting to know what it is. But what I've been saying is that there have been some differences in implementation, and obviously locally that's been very important for the Perth group. And I refer to things like the recommendation for a separate and new responsible gaming centre, which we have approved at a Crown Resorts level, and which is presently sitting with the Minister for approval. That's not necessary in Melbourne, but it's an example where locally this very important policy can be modified appropriately.
Well, what about in relation to the situation legally in Western Australia in respect of poker machines?
Yes, well, electronic gaming machines, it's unique, of course, to these properties, and responsible gaming with respect to it is appropriately provided for.
Yes, but isn't it more appropriate for the Burswood Limited Board to have responsibility for the oversight of the type of EGMs that are provided to patrons at Perth Casino, rather than someone on the eastern seaboard who is not subject to the same legal restriction?
Well, we have to operate these properties according to the licence conditions and the controls around the products we can offer. You haven't alluded to any reason why there would need to be any departure from any of the existing policies to accommodate electronic gaming machines. If you can give me an example, maybe I could do my very best to see why we would consider departing from it. But at the moment, I can't see that. The necessary differences are well and truly catered for locally, as they should be.
Does the responsible gaming team at Crown Perth report to anyone at Crown Perth?
They report through to the head of the group and through ultimately to Mr. Blackburn, so to Sonia Bauer, who's the head of responsible gaming.
Does the responsible gaming team at Crown Perth report to anyone located in Perth?
Other than keeping Mr. Bossy abreast of it, they report as part of the group function in the way that I've described.
You refer at paragraph 181, page 0208, to the 6th review of the Melbourne casino licence by the Victorian regulator in mid-2018. And then over the page at 0209, you mentioned that recommendations 6 to 16 made to Crown Melbourne related to responsible gambling measures. You see that?
Sorry, now I've got it, yes.
Now,
At 6 review, focused on it, yes.
Now,
yes.
At 182, you give evidence that all of the recommendations, if we can have 182 up, please. that have fallen due for implementation have been implemented. So the only ones in Melbourne that have not been implemented are the ones that are not yet due. That's 9 and the third limb of recommendation 8B.
Yes, it may be with 8B that there's some technical difficulties in delivering it. There may be a distinction with that one.
But is the sense of paragraph 183 of your witness statement that some of the recommendations from the Victorian regulator have been implemented at Perth Casino, but not all of them?
I'm sorry, I just can't, it's not up on my screen yet. Seems to have frozen. Now I've got it. May I just have the question again, please, Ms. Carl?
Yes. The sense of 183 is that some, but not all, of the recommendations of the Victorian regulator, which have fallen due for implementation, have been implemented at Perth Casino.
I think most of them have. There's, as I was just alluding to, there's an issue to do with the development of the Crown model, that tool, which I think is still in development.
Yeah.
Yes, there we go. At the bottom of the sentence, my recollection was correct, Ms. Carl. It's currently being developed. The expectation that a trial would be ready to commence.
Now, recommendations 14, 15 and 16 have not been implemented at the Perth Casino, have they?
I'm not sure what they are. If you could take me to them.
You can't tell me?
Well, not just off the top of my head.
All right. If we go to paragraph 187, please, at page 0211. And you're talking here about the RGAP that's made 2 recommendations in relation to the Perth Casino.
Yes, on time limits and spend, which has been implemented, and the evaluation of Crown Melbourne data, which hasn't been implemented largely because of access to the data. It's held by Intralot in Victoria, who's an independent gaming regulator.
What are the time and spend limits for EGMs that have been implemented at Crown Casino, as you refer? Sorry, at Perth Casino, as you refer to at 187A?
My understanding is that that related to, and it's recently been modified by an enhancement. I think it was 18 hours, and the spend I'm not sure of.
Changing topics here, Ms Coonan, does the Burswood Limited Board or the Burswood Nominees Limited Board have the capacity to set or approve an annual budget for the operation of the Perth Casino independently of the CRL Board?
No.
Does the Burswood Limited Board or the Burswood Nominees Limited Board have the capacity to make decisions about capital expenditure in respect of the Perth Casino independently of the Crown Resorts Limited Board?
Some, but not major.
Right. Can you give me a sense of what those not major decisions might be?
Major, well, some maintenance and things of that nature. I wouldn't be able to give you dollar amounts.
Does the Burswood Limited Board or the Burswood Nominees Limited Board have the capacity to procure funding for Perth Casino operations or capital improvements at the Perth Casino independently of the CRL Board?
Not unless it was very minor. So I think the answer to that would be no.
If we come back to the organisational chart, please, Ms Coonan, on the page with the heading Perth Group Executive Team, on the left-hand column, you've got I hope I'm saying his name correctly, John Salamoni, is that right?
Yes.
For the CFO, he's the CFO of Australian Resorts, reporting to Mr McGregor, who reports through to the CRL CEO, Mr McCann.
Yes.
Now, the only executive functions in finance that are Crown Perth based are the financial controller and the general manager of the Cage and Count. Is that right?
That's what the chart says.
and you don't know independently of the
I have no independent, I'm not in management. I have no independent knowledge of these roles.
The procurement function for Perth Casino is group-based, is it?
Just say again, sorry.
Is the procurement function for Perth Casino group-based?
Some would be local.
Would you agree that Perth Casino does not have any financial autonomy from the CRL group as a whole?
No, I wouldn't agree with that. I just don't know what the demarcations are, but there's obviously some in Perth.
Has the Board of CRL during your tenure ever discussed or considered the degree of financial autonomy the licensee of Perth Casino should have?
I'm not aware of those discussions, if they occurred.
At any time during your tenure as a director of CRL, have you considered clause 3.12 of the Burswood Limited Constitution?
Could I see it, please?
Yes, PUB.0026.0002.0001 at page 0010.
And it was
12.
Thank you.
You've seen that clause before?
Yes, I have, and I'm aware of that.
Yeah. And you understand it was a clause of the Constitution of Burswood Limited inserted by reason of a requirement in the state agreement?
Yes, I'm aware of that. Yeah. Same with Melbourne.
And it gives in the clause a description of what head office means?
Yes.
As a director of Burswood Limited, what do you regard to be the business of that company?
The business of the company is to conduct the licence and to manage the assets of the Crown Group. The Crown Casino and hotel and other functions in Perth.
And do you regard Burswood Limited as having central management or control over that business?
Well, I think it does control the local operations insofar as the matters that are rolled out here, the implementation of the group functions as they apply to the Crown facilities in Perth, and they certainly happen in Western Australia.
Do you regard Burswood Limited as having central management or control over the business you've just described?
Could you just clarify me what you mean by central management?
I'm just, you're not sure what that means?
Well, I'm just not clear because we've talked for a couple of hours about Crown Resorts' role and some central function. So are you referring to all of those, or are you referring to the day-to-day management and control which the Burswood Group has? Right. So I just needed a clarification for your question, please.
So you'd need to have some distillation of the concept of central management before you could answer that question. Is that right?
Well, look, there's lots of parts of central management. Do you mean all of it? Do you mean that nothing that Crown Resorts does should be done by Crown Resorts and it should all be in Western Australia? The way I take it, as the way in which I take it in Melbourne and the way in which I take it in Sydney, is that it means that whilst we've got a group function and group arrangements, central management and control of the properties relating to the day-to-day management are in Perth for Perth's purposes.
Now I want to move, Ms Coonan, to ask you about some movements in the management structure of the Crown Group in the wake of the Bergen inquiry.
Certainly.
Mr Barton's contract of employment with CRL was terminated earlier this year by mutual agreement, was it?
Yes.
Why did CRL board agree to that termination?
Well, it was mutual. So we agreed mutually that Mr. Barton would step down from his office.
Well, why was that something that the CRL board wanted?
It was largely a matter of some issues to do with the Bergen inquiry, but it didn't relate to much of Mr. Barton's long service for the company. There were some issues there, but there were some other considerations relating to him stepping down.
And what were they?
That he had decided in the circumstances that he didn't wish to remain with the business, and the business was prepared for Mr. Barton to step away from that office.
So was it entirely his initiative to...
No, it was mutual. Mutual means both of us came to that arrangement and both agreed to it.
So what were the issues about Mr. Barton emerging from the Bergen inquiry that meant that the CRL board also wanted his employment to terminate?
There were some issues to do with the regulator coming out of the Bergen inquiry as to Mr. Barton's suitability to continue continue in the business, continue in his role.
So effectively, it's what the regulator had to say and the opinions of the regulator that...
Ultimately, it was with all of the directors who stepped aside, apart from Mr. Horvath.
Now, if we go to CRW.507.006.1044_R, here's an agenda for a meeting of the Board of CRL of the 14th of February this year. At 1046, there's a memo to the board.
Yes.
And if we go to the...
I think it's a matter that should not go on a public screen, Commissioners.
I think it's not on the public screen. Is that correct, Operator?
It's not on the
Yes.
screen. If we go to the third paragraph, commencing Mr. Barton has served. Do you see?
Yes.
And then Mr. Barton's termination of employment is classified as without cause. You see that?
Yes.
So there was no reason from CRL board's perspective to terminate Mr. Barton?
Well, there are issues why he didn't wish to remain in his employment, and the business didn't wish him to continue to remain, but without cause related to his long tenure and other matters. So whilst there was some, well, put it this way, if you look at the total sweep of Mr. Barton's employment, that's correct.
But there was a matter of cause arising from the Bergen inquiry or the ILGA opinions about his suitability. Is that right?
Well, sorry, I didn't mean to cut across you. Would you say again? I'm very sorry to have interrupted.
So I think you were looking back over the whole of Mr. Barton's tenure.
I think these things have to be on balance and have to be looked at holistically. There was that opinion and there was the view of the regulator. But I think that things on balance have to be taken into account.
But the opinion of the regulator caused the CRL board to conclude that it was no longer appropriate for Mr. Barton to remain in his role.
We accepted his resignation.
Can you just answer my question, please?
Yes. Accept that, yes.
That it was the opinion of the regulator that caused the CRL board to accept or agree to the termination of Mr. Barton's employment.
Well, we didn't seek to have him continue. So it was really Mr. Barton's resignation.
So he resigned and you just accepted the resignation rather than it being mutually agreed?
No, it was mutual, as I said.
And the mutuality from the CRL board's perspective was because ILGA had formed adverse opinions about Mr. Barton.
We accepted that it was Mr. Barton wished to resign. We didn't resist that. His reasons were well known to us and we didn't resist.
did you share his view, his reasons? Did you have the same opinion?
Oh, I'm not entirely sure what was in his head.
All right. Let's go to CRW.510.041.0161. And here, this is just on the room screens.
Yes, now I have it.
Yes, the meeting of the CRL board of a few days later, the 17th of February 2021.
Yes.
And if we go to 1604.
Yes, I have it. Thanks.
Where are we? Oh, I see. Sorry. Yes. Let me go to 1613. There's something wrong with this. This is not the right document. Mr. Barton has entered into a services agreement, didn't he, with Crown Resorts
Yes.
Limited within a matter of days of the termination of his employment?
Yes.
And part of those agreed services include assisting CRL in the implementation of some or all of the recommendations arising from the ILGA inquiry.
Yes, I don't have it in front of me, but that's my recollection.
Yes, and neither do I, for some reason that it's not really evident to me at the moment, Ms. Coonan, but we'll battle on. Another service that he is providing under his service agreement is to assist you in relation to any aspects of his former position as CEO. Isn't that right?
Yes.
So why was CRL prepared to agree to the termination of his employment if it then immediately entered into a service agreement for him to continue to assist in the provision of the same services that he had under his employment agreement?
Well, they weren't the same services, and they're quite varied. Just recently, for example, Mr. Barton has been called upon to assist with his corporate memory in respect of some matters that have arisen in the Victorian Royal Commission. He's been of assistance to Mr. McCann, who's only quite new in the job, and he's available in respect of matters when he's called upon. That's not the job he had, and he doesn't perform it in the way in which he did.
Are you of the view that it's appropriate to retain Mr. Barton to provide those services?
Well, I was and am. It's the same arrangement that Crown entered into when it separated from Mr. Craigie, the previous CEO. So there was an arrangement there that has been of value to Crown. So, I mean, ultimately it's to do things in the best interests of the business. And it certainly was the judgment of the board that this was in the best interests of the business.
But is it really just window dressing, having it appear from the outside that he has left the company when he hasn't really?
Well, he's not present in the company all the time. He's present when he's called upon from time to time to do things. It's not window dressing. It's a fairly conventional way of separating, particularly with a CEO, and particularly a CEO of very long standing, when Crown has on its plate multiple issues that it has to work through, where you do need to be able to call on people's recollection and understanding of how things occurred and who may have been involved. Crown has been facing regulatory and other issues where the continued goodwill and cooperation of these people is of benefit to the business.
Now, can I ask you about Mr. Preston? Mr. Preston's contract of employment with the Crown Group was terminated late last year, wasn't it?
Yes.
Was that also by mutual agreement?
I believe so, but that was arranged with between Mr. Barton and Mr. Preston.
So you're not aware of the reasons why CRL agreed to that termination?
Well, Mr. Preston, as I understand it, wasn't well. He didn't wish to continue in that role. And there were also some issues to do with his evidence in the Bergen inquiry. So I wasn't privy to the exact discussions relating to Mr. Preston nor of Mr. Felsted, if we come to him.
If Mr. Preston had not wished to terminate his employment, would CRL have retained him?
Well, that's totally hypothetical.
So you don't know.
It's hypothetical.
Has CRL entered into any sort of agreement or arrangement with Mr. Preston for him to continue to provide services to the Crown Group?
Not that I'm aware of.
Mr. Felsted's contract of employment with Crown Group was terminated late last year too, wasn't it?
Yes.
Also by mutual agreement?
I don't know. It was arranged with between Mr. Barton and Mr. Felsted, but that's my understanding.
Right. Has CRL entered into any sort of agreement or arrangement with Mr. Felsted for him to continue to provide services to CRL?
Not that I'm aware of.
Mr. Bossy is the CEO of Crown Perth now, only on an interim basis, isn't he?
Yes, I think there will be, or possibly could be, some restructures. Mr. McCann has come into the business, and as new CEOs do, they look at the kind of management structure they wish to have. The arrangement with respect to Mr. Bossy was put in place, as I think I said a little earlier in the day, together with Mr. Crinnis in Sydney and Mr. Walsh in Melbourne, as a result of the abolition of Mr. Felsted's job as CEO of Australian Resorts.
So just coming back to Mr. Bossy, his role as a director on the Birdswood entities is also only interim, isn't it?
Well, that was the intention. If we can get to the point where we can have a locally based director, that would be appropriate then for the locally based director to take over as chair and Mr. McCann to join the board.
What steps have been taken to find a permanent CEO for Crown Perth?
Quite extensive steps. It may come as no surprise that with issues to do with managing inquiries, royal commissions and other regulatory matters, it is a difficult issue to attract suitably qualified directors, but the search goes on and we will be successful.
Are you able to say, sitting here today, when you expect or when CRL expects to make that appointment?
No, I can't do that.
But the expectation is if and when someone is appointed to that CEO position, they'll take Mr. Bossy's position as a director on the Birdswood entity boards. Is that right?
They may. That would be a matter for the board at the time.
And what's going to happen to Mr. Bossy if and when a CEO is appointed to Crown Perth?
I'm not sure that a CEO is going to be appointed to Crown Perth.
I said if and when.
Well, that's hypothetical.
And you don't want to answer that question hypothetically?
No, I don't want to answer hypotheticals. Mr. Bossy is performing his duties very effectively as far as I can tell. It will be up to Mr. McCann as to what kind of management structure he wishes to take forward, but I've got no reason to think Mr. Bossy wouldn't have a role.
But whether he returns to his Chief Operating Officer position or not, you're not in a position to say presently?
No, I'm not in management.
All right. Do you know who the current Chief Operating Officer of Crown Perth is?
On a temporary basis, no.
And you're aware, aren't you, of Mr. Bossy's long association with the Perth casino operations?
Yes.
What is the CRL board's rationale for the current retention of Mr. Bossy in a senior executive role at Crown Perth, given that long association?
Could you just say that again, please?
What is the CRL board's rationale for the retention of Mr Bossy at a senior executive level in Crown Perth, given his long association with the operations of Perth Casino?
I'm sorry, I just don't understand the question.
Mr Bossy is currently the CEO of Crown Perth,
Yes, he is.
and you're aware that he's been in a chief operating officer role, senior executive role with Crown Perth for many years.
Yes,
And you're aware, of course, of these various inquiries exposing issues of concern around the operations at Perth Casino and Melbourne Casino.
yes.
And given the issues of concern and his association with the Perth Casino operation over a long period of time, what is the CRL board's rationale for continuing to retain Mr Bossy in a senior executive position at Perth Casino?
Could you tell me what you're referring to, please?
Well, I think I just have, Ms.
No, well, you're talking about mentions, and I mean, I haven't followed all the evidence because I haven't been able to watch every word of what this commission has taken by way of evidence. So I just would like to know what it is that grounds your concern about the rationale.
All right, and without me giving that explanation, you're unable to answer my question. Is that right?
Well, I just don't know what you're alluding to exactly. I just don't know.
All right, let's talk about Mr McGregor then. He's a director. Sorry, let's go on.
Do you want to finish, Ms Kernan?
Thank you very much, Commissioner. What I was about to say is that throughout these commissions, various people have received adverse mentions and have been referred to in reports. The view I take about it is I think there are concerns. They need to be assessed carefully, but I think they need to be done in a measured way, and certainly with the benefit of allowing the Commission to consider the evidence and come to views. So rather than shooting Mr Bossy from the witness box, the view I take is that I think it is very important to understand all of the circumstances around what the adverse comment might be, understand what he says, and go through proper processes. That's what's been done with respect to, I think I've now moved on about 9 people in Sydney, or certainly across the business more broadly. And I've always tried to do it in a fair and appropriate way without jumping to conclusions. I realise there are issues that have to be worked through. Thank you for allowing me to give an explanation, Commissioner.
All right. Now, the present situation in relation to the governance of the Burswood entities is that Mr McGregor and Mr Bossy are the directors of Burswood Nominees and Burswood Resort Management. Is that so?
I think so, yes.
And you, Mr Bossy and Ms Fuster, are the only directors of Burswood Limited?
Yes, I think that's right. I think I'm a director of the 3.
Yeah. And who is to replace you when you leave as a director of Burswood Limited?
That will be a matter for the Crown Board.
Is it currently expected that Ms Fuster will remain on the board of Burswood Limited?
That would be a matter for Ms Fuster.
And is the Crown Group intending to refresh the board of Burswood Limited generally?
Yes, I can see a good case for doing that. I do support local representation on these boards.
Has the CRL board turned its mind to the optimal number of directors that should sit on the Burswood Limited board?
There are 5 on Melbourne as part of the requirement. There are 3 on Burswood. It may be that these are standardised going forward. I think local representation is effectively a good thing, but I do think that having a Perth-based director who's a member of the CRL board heading up the Burswood group is a good thing.
Right. Just following on from that, has the CRL board given consideration to the number of executive positions that should be on the Burswood Limited board?
Well, certainly no more than one, I think, is appropriate. But as far as a board decision, these are all matters going forward that would need consideration. We still have a very underpopulated board of Crown. We still only have 4 functioning directors, which is incredibly small number for a publicly listed board. We endeavour to meet all of the requirements, but the issues are largely to do with people who can be appointed but still take months to get probity. So at the moment we've got 4 people who got probity and 1 waiting probity and who's been waiting for many weeks.
So the focus of my question here, Ms Coonan, is whether the CRL board has given consideration to these matters. So not so much, so it's discussed the optimal size of the Burswood Limited board?
The People Nomination and Remuneration Committee has remit over these matters and makes recommendation to the board as to how the composition might best be filled.
And has it made recommendations to the board about the Burswood Limited board composition?
Not yet. We just had to fill the positions, Ms Cale, in the circumstances that I explained in February. And so that was, as I explained to Ms Fuster when I spoke with her, something that we'll revisit when we've got a Perth-based director to put into the proper mix.
To your knowledge, does the CRL board regard the refreshment of the Burswood Limited board as a matter of urgency or priority?
Along with many priorities, that's one.
And what's happening with the governance of the Perth Casino while that process of refreshment is underway?
It's continuing the way it has, certainly this year, because that's my direct knowledge of it, as I explained. So the governance is the way in which I've described.
Right, now going back to your witness statement at 104, page 0197, you give evidence of your awareness of conditions of the casino agreement between Crown Melbourne and the Victorian regulator.
Yes.
In particular, for the purposes of my question, Ms Coonan, clause 22.1 RA3 of that agreement, by which Crown Casino Limited has promised to ensure that Crown Resorts Limited maintains the Melbourne Casino as the flagship casino of Crown Resorts gaming business in Australia. My question is this: has CRL or Crown Casino Limited maintained Melbourne Casino as the flagship casino of CRL's gaming business in Australia to date?
I think it's frozen.
Steve?
I think we might take a break at not before 2:15, and if a message can be delivered to Ms Coonan that we seem to have lost her again. Thank you. So not before 2:15.
All rise.
Please be seated. Thank you, Ms. Coonan. We'll try again. Ms. Kale.
Thank you, Commissioners. So, Ms. Coonan, where I had you was in relation to clause 22.1A3 of the Melbourne Casino Agreement, whereby Crown Casinos promised to ensure that Crown Resorts Limited maintains the Melbourne Casino as the flagship casino of Crown Resorts gaming business.
Yes, I've got that. Thank you.
Has Crown Resorts Limited maintained Melbourne Casino as the flagship casino of CRL's gaming business in Australia during the term of the Melbourne Casino Agreement to date?
I believe so.
And how has it done that?
It's done it by, in effect, operating a casino or a business of the scale and scope of the Victorian facilities, by observing the requirements to have the affairs of Crown Melbourne conducted from Crown Melbourne on that board, by having the requisite number of executives resident in Melbourne in compliance, and by the way in which it's operated the agreement.
And what do you mean by that, the way it's operated the agreement?
Well, it's observed the agreement and it operates pursuant to the agreement a casino and associated facilities of the scale and scope, which means that it is the largest of the three. It services a much larger population than the other casinos, and it's maintained as the main one.
And what do you mean it's maintained as the main one?
That's how it operates.
Yeah, but what do you mean maintained as the main one?
Well, if it's the biggest and the population of at least, let's compare Perth, because Sydney doesn't exist yet, or it certainly doesn't operate yet as a casino. If you just look at the difference in population that the facilities service, I mean, Melbourne, what is it, 11.5 million, Perth 5.5, something, that it's the way in which it operates with that kind of patronage, those kind of numbers and that kind of size, and observance of the other requirements under the state agreements.
So apart from size and volume of patronage, are there features of the Melbourne Casino that Perth Casino does not have that contribute to making the Melbourne Casino the flagship casino of CRL's gaming business in Australia?
I don't think so. I think Crown Perth has facilities are very similar, superior in some respects. I think Crown Towers is a magnificent contribution to the Perth community. I know that it's a very important part of the Perth community. So I don't think there's any distinction in terms of quality of service, excellence, and attention to that kind of five-star experience.
And CRL intends to maintain Melbourne Casino as the flagship casino of its group going forward, does it?
Well, it intends to comply with the agreement.
Does it intend to maintain the Melbourne Casino as the flagship casino of the CRL group in Australia?
In accordance with its agreement, yes.
Do you perceive any conflict between your role as a director of Burswood Limited and your role as a director of CRL, having regard to that clause, the requirement to maintain Melbourne Casino as the flagship casino?
No.
Now, changing topics here, Ms. Coonan, I wanted to ask you a couple of questions about the consultancy agreement that Mr. Poynton had with CPH.
Yes.
Now, if we go to CRL.506.006.5524, minutes of meeting of the CRL board of 2 May 2018 at page 5535. Page 5535. And can you see at about point 5, other business director appointment?
Yes, I can see that.
and Ms Manos is advising the board.
Commissioners, I rise because this is another document in respect of which Crown seeks a non-publication order.
Right, that can be taken off the public screen. Thank you.
I don't think it was on the public screen, was it? Now, in the second... So if we go to the first dot point, there's the nomination there for Mr Poynton, and then the second dot point, there's this notification by Ms Manos about Mr Poynton's retainer by CPH. You see that?
Yes.
And there was a resolution passed at that point to appoint Mr Poynton to the board.
Yes.
It's not apparent that the board inquired first whether there was a written retainer agreement. Did it?
Not that I recall.
Do you recall whether the board, before resolving to appoint Mr Poynton, ascertained the terms of the retainer or its scope?
No, I had understood Ms Manos might have done that, but certainly I don't have any independent recollection of that discussion at board level.
Surely it was necessary for the board to understand the contents of that arrangement before deciding whether it was appropriate to appoint Mr Poynton to the board?
Yes, I mean, that's a reasonable point of view, I think, but with nominee directors, there's not a lot of discretion as to how somebody arrives on a board. For example, there wasn't, as far as I understand it, any examination of Mr Jalland, who was an employee, I think, of CPH. Mr Johnson was already on the board when I joined, but I don't recall an independent discussion of this.
Right. So do I understand from your evidence that you've just given that it wasn't an unusual thing to not inquire into the relationship between the nominee director and their nominator?
Well, not on this occasion.
Yeah. But my question is that, to your understanding, a usual position that the CRL board adopted?
I'm not sure. I don't have any other experience of that, apart from Mr Jalland, who was, I think, the chair of CPH and possibly an employee.
All right. And was there any inquiry made about any arrangement between him and CPH before his appointment?
Not that I'm aware of.
And when you say there's a limited scope to inquire into that relationship, excuse me, or challenge it, it would obviously be of interest, wouldn't it, to the CRL board if a nominating party or shareholder were to have an arrangement where, for example, confidential information of the board was required to be passed to that nominating shareholder.
I agree with that.
That would be unacceptable.
I agree.
So that would be a situation that you would want to know about before resolving to appoint somebody to the board.
Well, I think it would be relevant in terms of the ability of the nominee to be able to fulfil their role appropriately.
But that inquiry wasn't made of Mr Poynton.
Not that I'm aware of. It may have been made by the Nominations and Remunerations Committee, but not at this point, which is the first point at which I was aware of it.
Do you recall if and when the CRL board obtained a copy of Mr Poynton's consultancy agreement?
I don't know. I saw it in the bundle that I was given yesterday for the first time.
Oh, so you'd never seen it before?
No.
So can I just understand this? You recall that in October 2018, the CRL board approved a controlling shareholder protocol with CPH?
Yes, I do.
And which enabled the sharing of confidential information by of Crown to CPH and Mr Packer?
Yes. Yes, on certain terms, yes.
Yes, and that protocol was examined and some findings were made about it in the Bergen inquiry.
Yes.
Yeah. And as a result of what came out of the Bergen inquiry in October 2020, it became apparent to both CPH and CRL that that protocol should cease.
Yes. It was reviewed earlier than the Bergen inquiry in about June of 2020. I had asked that it be reviewed by the company's then lawyers, Minter Ellison. And so it was reviewed, and the advice was that it didn't need to be changed, but whatever information got passed should be recorded in writing.
And did it occur to the board, or did the CRL board take any steps after it's ceased the protocol arrangements with CPH itself to consider the arrangements between Mr. Poynton specifically and CPH that it had been advised of back in 2018?
No, the actual arrangement, the terms of this arrangement with Mr. Poynton only became apparent to me, at least. I don't know whether others knew. Obviously, the CPH nominee directors would have known, but the independent directors, I don't think, had any line of sight into it. And as I've said, I saw it for the first time in a bundle yesterday.
But when that protocol was terminated between CPH and CRL, did the CRL board turn its mind to whether it should investigate whether any directors individually had separate arrangements with CPH for the passing of information?
No, we dealt with what we knew about, which was the shareholder protocol and the other protocol with respect to provision of services.
And you're aware that Mr. Poynton terminated his arrangement with CPH on the 10th of February 2021 this year? Or 2020?
Yes, I think he tried to do it earlier. He did mention to me that he wanted to be free of or independent of CPH. So there was an earlier, I think, conversation. And I understand that he provided notice of termination to Ms. Manos.
Now, was that something, that termination, entirely of Mr. Poynton's own volition, or was the CRL board either insisting or encouraging him that he do so?
No, I think the CRL board, leaving aside the nominee directors, were conscious of the fact that it would be very difficult for Mr. Poynton, having been a nominee director of CPH, to become independent just by severing whatever relationship he had with them. Our charter provided, I think, for 3 years lapse of time between designated type of arrangements and independence. So I think that was the mindset of the CRL board. I think Mr. Poynton had in mind the fact that he was independent from Mr. Packer and that he should be able to continue on the board as an independent.
So did...
Just, Ms. Coon, another technology matter. Could you please check that your computer is on mute, please?
I might have to get some assistance here to drive this, Commissioner. I'm assuming somebody will rescue me. Commissioner?
Got no idea what you're talking about. You right? Please continue. Thank you.
So, Ms. Coonan, just coming back to Mr. Poynton's consultancy agreement.
Yes.
Do you recall either yourself or any member of the CRL board expressing to you concerns about the contents of Mr. Poynton's consultancy agreement with CPH?
In the last few days, since it became public. That's the only concerns. Nobody had concerns earlier because, to my knowledge, no one knew about it.
All right. So when you say in the last few days, do you mean since Mr. Poynton's given evidence to this Royal Commission?
Yes, I understand there was some evidence to this effect, that he had a written agreement and as to the terms of it.
Here. Now, finally, Ms. Coonan, I want to ask you a couple of questions about the corporate culture of the Crown Group. When you gave evidence to the Victorian Royal Commission, I don't think this was your own expression. I think it's one that you adopted that was put to you by senior counsel assisting in respect of certain conduct of Crown Group that was being examined, and he and then you were referring to old Crown, if we can put air quotes around that. Do you recall that?
Yes, it's emblazoned in my mind, Ms. Cale.
And I assume that when you were using the term old Crown, you were identifying what you understood to be a previously prevailing corporate culture within the group.
Yes, sorry. I think we're right. Thank you. Apologies. Well, I've just got someone helping me here. Thank you. Yes, I mean, I think it was a conglomerate of circumstances perhaps that might have sat under the idea, under the notion of culture.
All right. So if I could ask you to describe in summary your understanding of the culture of Old Crown.
Well, it was a very unusual culture, I think, as cultures are with successful major shareholders, founders of businesses, if that's the right description. And I think Crown has been on a journey of going from perhaps one influenced by the majority shareholder and founder into perhaps more the stance of a listed public company with all of the outward facing obligations and transparency of modern corporate governance.
So I plan to give you the opportunity to explain any shift in corporate culture that you've perceived to have happened and what that different culture looks like now. But can we just go back to the old culture and for you to give us a sense of what that culture was?
I think it was one where certainly from management's level, they were very beholden to the major shareholder who was part of the business for a significant period of time. And when the major shareholder stepped back from having that sort of involvement, I think management still, in many respects, thought that they were reporting to the major shareholder. I think that affected the way in which people carried out their functions. At board level, it meant that there were certain reporting lines which, or at least the risk management structures and the reporting lines to the board were very blurred. There was asymmetrical information where some information was given to some directors and not others. And it was a situation where it was very difficult from a board perspective to actually end up with enlivened suspicions about things, because the way in which matters were presented didn't raise those kind of issues. Now, that's a long-winded way of perhaps saying that might have been culture, but it's very, very different place now, as you've heard in both Victoria and to some extent in New South Wales, although it's much more developed now.
Right. Can I just take that last point that you identified? Do I understand you to be saying in terms that as a director of CRL, there was a concern that the way in which information was presented wasn't necessarily open and balanced to enable you to see the full picture?
I think that's right. And even if you had and did at times pursue, ask appropriate questions and pursue lines of inquiry, it wasn't necessarily going to yield the full picture.
And when you referred in your longer answer to the influence of the major shareholder, you're referring, of course, to CPH.
Yes, I mean, it was influence. I mean, they didn't have actually the numbers on the board, but CPH had influence and they've recognised that, which is why they've stepped back. It was a very central part of the Bergen report that the CPH influence had effectively or had infected the operations of Crown.
Yeah, and the CPH influence is, in practical terms, synonymous in your eyes with Mr. Packer's influence. Is that right?
Not only Mr. Packer, I mean, and CPH. So certainly not only Mr. Packer. Mr. Packer did step back from the business, and it's interesting that the evidence in Bergen, in the Bergen inquiry, I think Mr. Packer himself said that he appreciated that his influence may have continued even though he stepped back.
Now, just in terms of cultural change, you would perceive that there has been a degree of cultural change to date, would you?
Yes, I think a huge amount of cultural change.
And I'll give you the opportunity to just elaborate on that if you wish to.
Yeah. Well, I think the first thing when you start to look at culture in an organisation is tone from the top. And that was very much the starting point after the Bergen inquiry when there were a few independent directors who were able to take a different direction with the company. There had been some earlier work in relation to culture the previous year, but we were enabled to escalate it after the Bergen report. That meant that apart from tone from the top, it has been necessary to get some external help to actually benchmark Crown's present culture, to look critically at what its future state should be, and to get a roadmap to go there. And the Deloitte's have been carrying out that exercise, and it's almost to the point where I think the framework is ready to be rolled out right across the organisation. It has meant that we have set up a new HR function and a new head of people and culture, Mr. Weston, to oversee that together with Mr. McCann, who's done it elsewhere in his previous organisation, Lend-Lease. I'm very confident that this will be the right tone that will go right through the organisation together with the reset of the risk management structure. We now have a risk-aware and compliant culture where the prevailing notion is if you see something, say something, do the right thing, and the psychological safety of the staff in being able to speak up. That's been encouraged very much by me and my fellow directors. I've been communicating with Crown's 20-odd thousand employees every week with a newsletter which encourages them to contact me, gives them all of the ways in which they can escalate their concerns right throughout the organisation. As well, of course, there's some very new people in the organisation, new management to lead it. We've got, as I've said, Mr. McCann, Mr. Weston, we've got Mr. Blackburn, Ms. Ottner, who I talked about, and various others who are able to provide a very different tone for the kind of culture that Crown wants. We've aligned our values, I think, to our purpose. I think we're getting it well lined up, and I'm very confident that the structures are now there to have a culture of, as I say, a risk-aware and compliant culture to deliver our purpose and values.
And do you perceive that this cultural change has filtered down to Perth Casino yet?
Well, I get a lot of feedback from the Perth Casino into my chairman's inbox. I do think that it is actually now penetrating right through. what we expect. I think the expectations are clear. We have nil appetite, and this is conveyed, we have nil appetite for matters to do with breaches of regulation, with anything to do with criminal influence. We've communicated together with other ways in which we've set our overall risk appetite to staff, right down that this is what we're expecting and this is what we want as part of a compliant, ethical and clean operation.
Thank you, Ms Coonan. I have nothing further.
Thank you, Ms Kale. Any applications?
Commissioner, I seek leave to cross-examine on some issues relating to the operation of Burswood Limited Board.
Mr Ward.
Thank you, Commissioner. Ms Coonan, my name is Ward and I appear for Mr Poynton.
Mr Ward?
Ms Coonan, can I just start by going back to something you said right at the start of your evidence in answer to a question from Ms Kale. You said that you appointed Mr Poynton as chairman of Burswood Limited in 2020. Is that right?
Yes, I think that's correct.
Yes. And in your capacity as chair of Crown Resorts Limited, you effectively had the power to control the composition and to some degree the operation of the boards of those subsidiaries, didn't you?
Together with the Nomination and Remuneration Committee, who looks at all of the appointments and then makes the recommendation to the board.
And so at a practical level, you had authority to direct Mr Poynton to provide reports to the board of Crown Resorts?
That was what he was required to do. That's what I said in place.
And your words, you directed him?
Yes, well, I mean, I said, please, I would like some reports delivered to the CRL board, and he said yes. And
you also caused the February 2021 subcommittee board meetings to be, subsidiary board meetings to be cancelled. Is that right?
That was in connection with the delivery of the Bergen report and the fact that we wouldn't have been able to populate all these committees in the immediate aftermath, which I anticipated. And I wrote to all of the directors and said this was my plan to get us over the report being delivered and asked for any response from any director, and I didn't get any.
So if the operator could please bring up CRW 515-003-1312.
I actually have it in hard copy, Mr Ward.
For the benefit of everybody else, we'll just have it brought up on screen.
Okay.
That's the email you're referring to by which you,
Yes.
in effect, cancelled the subsidiary board meetings.
Yes.
Now, as far as you're aware, your predecessors as chair of Crown Resorts Limited had similar control over the operation and composition of the boards of subsidiaries?
Well, I had no line of sight into that, but I would assume that's correct.
Well, for so long as you were a director of Crown Resorts and Mr Packer or Mr Alexander were in the chair, did you observe them to have similar control over the composition of the boards of subsidiaries?
Well, I never actually attended any of those meetings. The process was that the People and Nomination Committee would consider the composition of committees and make a recommendation to the board.
Well, perhaps if we can just turn then to the composition of the board of Burswood Limited throughout the time that you were a director of Crown Resorts. You were aware that Mr Barton was a director of Burswood Limited through all of that time?
I don't know for what period, but certainly for some period Mr Barton was.
Aware that Mr Felstead was a director for all of that time?
I'm not sure.
You're aware that Mr Craigie was a director through the period up until 2017?
He may have been.
Are you aware that Mr Alexander was a director and chair for part of that period?
Yes.
You're aware that Mr Packer was the chair of Burswood Limited up until 2016?
He may have been. I think he was, yes.
Aware that there were two external independent non-executive directors Mr. Poynton and Mr. Roberts,
Yes.
and more recently Mr. Roberts replaced by Ms. Fuster.
Yes.
So would you accept that throughout the whole of that period, the board of Burswood Limited was comprised generally by the group chair, the group CEO, the Perth CEO, possibly one other executive of Crown Resorts, and two external non-executive directors?
I think the answer to that would be yes, but I'd have to see the appointments and the times to be absolutely certain. But as a general proposition, that's probably correct, Mr. Ward.
Now, Burswood Limited had no employees at any time, did it?
No, not that I'm aware of.
The boards of Burswood Nominees and Burswood Resort Management were all appointed by Crown Resorts, weren't they?
I would expect so.
And so the board of Burswood Nominees, were you aware that through most of the last 10 years it was comprised of Mr. Barton, Mr. Felstead and Mr. Craigie?
I don't know. Not for 10 years. I just don't know.
Were you aware that those boards all comprised executives of Crown Resorts or of Crown Perth?
No.
You were aware that there were no independent non-executive directors on the board of Burswood Nominees?
No, I'm not in a position to agree with that. I don't know.
So you don't know who was on the boards of those companies?
Well, that's not quite right. You asked me about nominees.
Okay, of Burswood Nominees. Were you aware who was on the board of Burswood Nominees prior to your appointment in May of this year?
No.
Were you aware of who was on the board of Burswood Resort Management Limited prior to your appointment in February of this year?
No. After February, that's my remit over Burswood, as I explained. It's been a couple of months.
Now, Burswood Nominees is a subsidiary of Burswood Limited, isn't it?
Yes.
And Burswood Limited is itself a subsidiary of Crown Western Australia Proprietary Limited, isn't it?
I understand so, yes.
Yes, and you're a director of that company?
I think I'm a director of all companies. I think currently about 60, and shortly not to be, Mr. Ward.
And Mr. Bossy is the other director of Crown Western Australia Proprietary Limited, isn't it?
I think that's right.
Now, does that company have a board charter?
Look, I don't know. I'm sorry about that. I couldn't tell you.
Is that company at all responsible for implementing the strategy of Crown Resorts in Western Australia?
Which strategy?
Well, you said earlier in answer to questions from Ms. Cale that Crown Resorts sets the overall strategic direction for operations in Western Australia.
Crown Resorts does, yes.
Yes. So is Crown Western Australia Proprietary Limited responsible for implementing that strategy in Western Australia?
The three entities that comprise Burswood, as I've said in my evidence today, Limited, Nominees and Management, that group is responsible for implementing the strategy in Western Australia.
Like Burswood Limited, Crown Western Australia Proprietary Limited has no employees, does it?
No.
And Crown Western Australia Proprietary Limited is also itself a wholly owned subsidiary of Crown Entertainment Group Holdings Proprietary Limited, isn't it?
Yes, I think that's right. You might just have to show me the group structure.
Well, you're a director of that company as well, aren't you?
Yes, as I said, I think I'm a director of all companies and soon not to be.
And that company also has no employees?
I don't think so.
So the implementation, in answer to Ms. Cale's questions, you said that Crown Resorts Limited sets the overall strategy, but it's implemented in Western Australia by Crown Perth. You agree with that?
Yes, well, I mean, local operations are implemented there.
They are implemented by employees of Burswood Resort Management, aren't they?
They're technically employees, yes, of Burswood Resorts Management.
And some of them are employees of Crown Melbourne who work in the group structure.
Yes, that's right.
Now, would you agree that you can't implement a strategy without employees?
I think it would depend on on what you're talking about, Mr. Ward. Can you? What do you mean?
Well, only an executive management can implement the board's strategy, can't they?
Oh, I see what you mean. Yes, yes.
The directors themselves do not have power as directors to implement a strategy. They implement it through employees.
I think that's right. You just broke up there for a minute, Mr. Ward. Did you say that directors can't implement?
Directors themselves can't implement a strategy. They implement it by giving direction to employees. It's the employees who implement the strategy.
Sorry, you're breaking up again. Executive directors are in a different capacity to non-executive directors, but I think your proposition broadly, if I understand the question, is that you have to give directions to management to implement operations.
Thank you. Now, would you agree that to the extent that the board of Burswood Limited was involved in implementing the strategic direction imposed by Crown Resorts, the board of Burswood Limited worked within the parameters that were effectively given to it by Crown Resorts and by the executives that were on the board of Burswood Limited? Do you agree with that?
No, I think that Burswood had independent oversight of operations. They didn't implement it, but they had oversight. That was their job, to oversight the implementation of strategic directions. Certainly they were CRL directions, but it was an oversight role, not an implementing role.
And why do you say that Burswood Limited is different in that respect than Crown Western Australia or Crown Group Holdings?
Because they were not regarded either conventionally by the regulator or by the way Crown operated as part of the three Burswood, the Burswood Group, namely limited, nominees and management, because of the trust structure.
The sole job of Burswood Limited was to hold the units in the trust, wasn't it?
Yes, they're the unit holder.
Yes. And because the board was comprised by 3 or 4 executives and 2 non-execs, those independent non-executive directors might comment on things that were proposed to be done through the board, but ultimate responsibility and control rested with the executives and the Crown Resorts Board, did it not?
Well, I don't know exactly what you're getting at, Mr. Ward. I don't really understand the question. Non-executive directors have got duties and obligations like anyone on a board.
Accepting, Ms Kernan, that they have the duties of directors to act in a fiduciary manner toward the company, nonetheless, in the way this board was structured and its composition was set by Crown Resorts, the independent directors could not themselves override the executive directors, could they?
Well, was there some reason to? I mean, I don't know whether you're grounding this in some kind of legal theory or are you grounding it in some kind of fact? I just don't know. I'd love to help if I can.
Well, perhaps we can just deal with it as a simple fact. If a resolution came to be considered by the board and the executive members of the board voted for it and Mr Poynton and Mr Roberts voted against it, the resolution would not pass, would it?
Well, that happens with numbers on any board. That's correct.
Now, Ms Cale asked you whether the Crown Resorts Board has ever defined what matters the Burswood Limited Board could direct the Crown Perth CEO on. Do you remember that exchange?
No. Could you just tell me again?
Ms Cale asked you whether the Crown Resorts Board had ever defined what matters the Burswood Limited Board could direct the Crown Perth CEO on?
Yes, that's what she did.
You recall that your answer was that it's difficult to define, they might be able to deal with some local matters.
Well, I don't know that I quite said that, but what I meant was that the Burswood Group, at least Burswood Limited, certainly the way it conventionally operated, had oversight of the operations of management in the Perth properties.
The simple and direct answer to Ms Cale's question is that it has never been defined what matters
Yes,
the Burswood Resorts Limited Board.
Absolutely true.
It has never been defined, thank you.
Has never been defined.
And it's never been necessary to define it because the Crown Resorts Chair, Crown Resorts CEO and the Perth CEO have always sat on that Burswood Limited Board, haven't they?
Well, the second part of your question is correct, that those people have sat on the board, but I don't know that it necessarily follows that that's the reason why it didn't get defined. I think it should be defined, and it will be.
And likewise, because of that degree of control of the board, as a matter of fact, it's never been necessary for that board to have a separate charter, is it?
I don't know that that's the reason.
Well, there's no need for the board of Crown Western Australia Proprietary Limited to have a charter, is there?
I don't know. I'll have to have a look at that.
There's no reason for the board of Crown Entertainment Group Holdings Proprietary Limited to have a charter, is there?
Not that I would think so, but I do think the Burswood Group needs one. They should have had one, and they will get one.
Now, when you told Ms Cale earlier that the Burswood Limited Board has effectively operated to give directions to Burswood Resort Management, to the management company, that was because the Group CEO, the Group Chair and the Perth CEO were all sitting on that board, wasn't it?
Well, they were able to give directions.
Do you remember being asked by Ms Cale about the Crown Perth CEO's report, and you were shown a section of that report regarding electronic gaming machines and the reduction in time between games from 5 seconds to 3 seconds?
Yes, I do.
Seeing that document?
Yes.
That's not a matter that the Crown Perth CEO would ever have had authority to do independently of the Crown Resorts CEO, is it?
No, that's it. As I said, it's an important matter, but it could not, nothing could happen with that other than locally, together with the WA regulator and as part of the Perth service offering.
Yes.
So it was very much a local matter.
So there has to be a proposal.
Whether it could be implemented or not.
So there has to be a proposal put up to the regulator.
Definitely.
And that proposal might be put forward by the Crown Perth CEO, but the Crown Perth
And
CEO would not do that without the Crown Resorts CEO approving it, would he?
Well, I would think not, but the dealings with the regulator were always at local level and always by local Perth management.
And if a proposal like that was to be put up and it was something that the independent directors disagreed with, they could raise their concerns, but they couldn't stop it, could they?
Well, I mean, that's entirely speculative, Mr. Ward. I mean, I don't know. You'd have to see what happened at the time.
I'm asking not as a speculation about a hypothetical event. What I'm asking is, as a matter of practice on the operation of this board, if the independent directors had a concern with a proposal like that being put up, they could raise their concerns, but they couldn't stop it, could they?
Well, you can always raise concerns on a board and it will depend on the numbers.
Ms Coonan, in an earlier part of your evidence in questioning by Ms Cale, you were taken to something that Mr Poynton said in his evidence, and Ms Cale described it as in summary that Mr Poynton said that his role was ambassadorial. Can I just link that to something you said earlier about the need for local Western Australian directors?
I think that's a good idea, yes.
Your view is that there needs to be somebody local who is plugged into the local business, economy and political scene to provide input. Is that right?
I'm not sure about political, but certainly somebody who is familiar with the property, familiar with the community, familiar with stakeholders. Yes.
And that's particularly useful in a non-executive independent director because they provide a sort of broader view than just the management view. Is that right?
It can be, and I think that's one of the roles of a non-executive director, to bring whatever the sum total of your experience is to a role.
And so whilst they might be bringing that broader perspective, they're not directly being engaged as a director to manage the operations of the company, are they?
I think so. I mean, basically your primary duty is to the company.
Yes, so they have a duty as a director to act in the interests of the company, but they're not engaged to manage the company in the same way that you've been doing for the last year as managing director of Crown Resorts. Is that right?
No, well, a non-executive director is not a manager.
Thank you. Can I ask that the transcript of Mr. Poynton's evidence be brought up at page 1407, lines 24 to 33?
Yes, I've got it now.
You can just pull out that particular passage. So can I just ask you to read that, Ms. Coonan?
Yes, I'll read it, Mr. Ward, just a moment. Yes, I've read that now.
Now, having read what Mr. Poynton actually said, you wouldn't disagree with that proposition, would you?
Which part of it?
That paragraph on screen in front of you. You wouldn't disagree, firstly, that being a director of a wholly owned subsidiary is different to being a director of a company that actually employs staff and operates a business. You don't disagree with that proposition, do you?
No.
And you don't disagree?
Well, it depends what the subsidiary does, of course.
You don't disagree with the proposition in the third sentence that when he says they, he means the non-management directors, himself and Mr. Roberts, they were never envisaged, they were there to provide political and economic overview about the situation in Western Australia. That's consistent with the evidence you just gave a moment ago about the desirability of non-executive directors having that input, isn't it?
I said that could be useful as that you bring the sum total of your experience to your roles and obligations and duties as a director, is what I said.
And you wouldn't disagree with the proposition in the next sentence that it was never envisaged that the company and its directors would be directly responsible for the management of the casino.
Not directly responsible, but responsible for overview of the way in which the Burswood Group operated, would have been my interpretation. Mr. Poynton has a different one about how he did it for 15 years. I wasn't there to see how he viewed that.
So whilst you might have disagreed with Ms. Cale's summary of Mr. Poynton's evidence, having now seen it, you don't disagree with what he says in that paragraph, do you?
Yes, I do.
Specifically, in what respect do you disagree?
Well, let me just go through it. I think it depends what the subsidiary does.
Well, that's not disagreeing, that's asking for further information, isn't it?
This whole paragraph I don't agree with, then, if you want to take it as a whole. I don't know what was envisaged at the time of his appointment, which I think was back in 2004 or 2007 or before my time anyway, so I don't know what was envisaged.
So the answer is you don't know, not that you disagree with what happened 15 years ago.
No, I just don't know what happened 15 years ago.
In that case, you can't assist the Commissioner any further with that question.
I don't think Ms Coonan had finished, Mr Ward. Had you finished your answer?
No, thank you, Commissioner. I was just trying to be helpful here rather than let this go, because Mr Ward's question deserves that to be answered. I don't really know how Mr Poynton reconciles being an ambassador with duties as a director. I think you can be an ambassador as well as a director. I think good officers and people who are friends to businesses, that's a good thing, and I think Mr Poynton did that. But I don't know that I can extrapolate from that was the sum total of his understanding, obligations and way in which he carried out his duties as director. I just can't say that.
You don't know how he carried out his duties as a director, do you?
Well, he says here how he did it, and I don't agree that that's a correct way to describe duties as a director.
I have no further questions.
Thank you, Mr Ward. Any other application? Mr Penglis.
One short topic, if I may, with leave. Ms Coonan, my name is Penglis and I represent Mr Preston.
Yes.
Ms Coonan, you were asked by Councillor Sistine after lunch about your recollection of the circumstances upon which various people left the employee of Crown.
Yes.
Including Mr Preston and Mr Felsted.
Yes.
Is it fair to say that sitting there today, I was going to say here, but sitting there today, you have no independent recollection of those matters?
Well, that's not quite right. I just don't have any granular detail of how the separation with Mr Felsted and Mr Preston occurred. That was actually conducted by Mr Barton.
So Mr Barton gave evidence to this commission earlier this week. And I just want to share that with you to see whether it refreshes your memory, whether you agree with it or disagree with it. That's all I'm going to ask you. In essence, Mr Barton gave evidence to the effect that they left the employment of Crown on the basis of redundancies as a result of an organisational restructure. Does that help jog your memory one way or the other?
Yes, that was a presentation to the board by Mr Barton and his proposal with respect to those roles.
And the board accepted his recommendations or his proposal, as a consequence of which the positions held by Mr Felsted and Mr Preston respectively disappeared.
That's true, but I think in all fairness I have to say that there was some impact in relation to comments in the Bergen inquiry, but Mr Barton gave evidence. I've no reason to disbelieve him or contradict him.
Mr Barton said in his evidence to this commission that the restructure, the organisational restructure, was driven by some imperatives that were coming from the work that you were carrying, you being Crown, were doing through the course of the restructuring. Would you disagree with that or agree with that?
No, that's certainly true as well.
And I asked Mr Barton a question with he agreed, and what he said was that, in effect, he agreed with this, that the proposition that I put to him with which he agreed was that it would be wrong for anyone to suggest that Mr Felsted or Mr Preston left the employee for any reason other than the structural reorganisation that Mr Barton referred to. He agreed with that proposition. Do you?
Yes, but I mean, to be perfectly honest, there were some comments that concerned the Crown Board, but Mr Barton's evidence is correct, just as I gave evidence today as to the way in which we separated from Mr Barton. It wasn't the only factor, but Mr Barton's evidence is correct. There was a restructure. There were redundancies in respect of both Mr Preston and Mr Felsted.
May I please, Commissioner?
Thank you, Mr.
Mr Commissioner, my name's Kewitt and I appear for the CPH companies. I have a couple of questions, if I may.
Yes.
Ms Coonan, my name's Kewitt and I appear on behalf of the CPH companies. From the time that you commenced your position, Ms Coonan, Mr Craigie was the group CEO until April of 2017. Is that correct?
Yes, that accords with my recollection.
And do you recall what Mr Felstead's position was until April 2017 while Mr Craigie was Group CEO?
I think he was. I think he reported to Mr Craigie, but I can't remember the name of his position.
And you had discussions with Mr Craigie over that period of time?
There were many discussions over that period of time. I'm just not sure.
It was a very
if you're asking me to recollect what.
It was a very bad question. I'll narrow it. You had discussions with him in respect of his obligations to report to Mr Craigie? That is, that he was obliged to report to Mr Craigie?
Mr Felstead?
Yes. Yes.
Don't recall having a conversation with Mr Felstead about that.
Do you recall Mr Felstead making it clear to you that he understood his obligation was to report to Mr Craigie as the Group CEO and not the CPH companies or Mr Packer?
Oh, I follow what you mean. Would you just mind repeating it again? I'm very sorry.
And I'm not suggesting there was a particular conversation in those words.
So I didn't. I mean, I was a non-executive director, so my involvement in these kind of conversations might have been pretty limited. But I want to assist you if you can take me to something that I might be able to help with.
Your interactions and conversations with Mr Felstead made it clear that Mr Felstead understood his obligation was to report to Mr Craigie, not to report to Mr Packer or the CPH companies.
Well, I only ever had experience of Mr Felstead reporting to Mr Craigie in relation to board meetings.
Until February 2020, it's the case that there was no nominee of the CPH companies on the Crown Risk Management Committee, the CRL Risk Management Committee. Is that correct?
I'll have to take your word for it. I'm sorry, my memory doesn't extend past thousands of meetings.
Certainly you can't recall, if I can ask it the other way, you can't recall there being a nominee of the CPH companies on Crown's Risk Management Committee, can you?
Well, I wasn't a member of the committee, Crown Risk Committee at all until 2020, until 2021.
You were asked some questions, Ms Coonan, about the controlling shareholder protocol entered into in 2018. You supported that protocol being entered into at the time?
Absolutely. It's a fairly conventional way of arrangements between nominees and a major shareholder in my understanding. And if it's properly observed, it's appropriate.
And the other independent directors at the time agreed to enter into that arrangement?
Yes.
And I take it from what you've just said that at the time that you entered into the arrangement, or that you decided to enter into the arrangement, you considered it to be in the best interests of Crown to do so. I
did, and we had legal advice to that effect.
Yes. May it please the Commission.
Thank you, Mr Kewitt. Any other applications? Mr.
May it please the Commission, I'd seek the Commission's leave to ask a few questions about the last sentence of paragraph 8 of Ms Coonan's statement.
Go ahead.
Thank you. Ms Coonan, my surname is Power, and I appear for Ms Fewster.
Yes.
I won't keep you too long. Can we please have paragraph 8 of Ms Coonan's statement brought up, please? Ms Coonan,
yes.
I'd like you to read the last sentence of that paragraph for me, please, and if you need to read the rest of it, please do.
Yes, I know, I've read it. Thank you.
Thank you. Now, that conversation that you had with Ms. Fuster, I'm told that that was a telephone conversation where you
Yes.
called her late on the afternoon of the 28th of February 2021. Does that sound right to you?
Yes, I think that's correct.
All
And
right,
it was definitely a telephone conversation.
thank you. I'd like to now bring up another document. I'm told the identification number for this is FEW .0002 .0001 .0015. Now, some of that information should not be on the public screen. Thank you. Thank you. Ms. Coonan, you may not have seen this for some time, so please let me know if you need the opportunity to read through it. You'll see it's an email from Ms. Fuster to Mr. Poynton of the 18th of February 2021,
Yes.
and you
Yes.
are copied into it.
Yes, I was.
Just take a moment to read it.
Yes, I will.
Thank you. Let me know when you've done that.
Yes, I've read that. Thank you.
And I want to focus in particular on the last two paragraphs. Now, the conversation that you had with Ms. Fuster late on the afternoon of the 28th of February 2021, I'm told, was about the contents of those last two paragraphs. Is that correct?
No, I don't recollect it. I recall that either Miss Manos, who was then the group counsel, or Miss Harris contacted me and said, we need to repopulate some appointments to the board. This was at a time of great crisis, of course. And in view of these resignations, I was the only person left who could take the chair, and there wasn't anybody who was prepared to take the other position other than Mr. Bossy. I rang Miss Fuster and had a very pleasant conversation with Miss Fuster, and explained that this was the best I could do in the circumstances to have appointments, have these appointments made, and that when there was an opportunity to have a Crown-based director replace Mr. Poynton, that's when we'd look at how to structure the board. I think she may have mentioned that she was concerned about these matters.
Well,
I haven't any reason to disbelieve that she raised them.
yes. Well, this email, of course, preceded the telephone conversation. And
Right.
One of the reasons why you spoke to her on the 28th of February was to deal with the misgivings that she had expressed in those last two paragraphs, wasn't it?
Yes.
And what you
Well,
told,
you don't know about, can I just clarify that?
of course.
I'm not sure so much about the misgivings, but I wanted to give her an explanation as to, why I didn't have any other alternatives.
All right. And is one of the things that you told her during that conversation that which you refer to in paragraph 8 of your witness statement, namely that Mr. Bossy's appointment to the board of Burswood Limited would be on an urgent basis pending the appointment of additional Perth-based independent directors.
Yes.
And was it your intention at that time to do your best to ensure that there were some independent Perth-based directors appointed as soon as you could have that done?
Yes, appropriately qualified, independent, Perth-based directors, definitely.
Thank you. I have no further
Thank you,
questions.
Mr. Power. Anything else? Mr. Evans?
A couple of topics if I could. Thank you, Commissioners. Ms. Fuster, my name is Evans. I appear for the Gaming and Wagering Commission in these proceedings.
I'm sorry, Mr. Evans, is it?
That's correct. Ms. Fuster.
Oh, I didn't hear. Yes, I'm Coonan, not Fuster.
My apologies. Picking up from my learned friend, Mr. Power.
Bad vibes.
It's been a long day, Mr. Evans. I understand.
And it's later. It's later for you than it is for me.
I'm glad you noticed.
For this reason, I will try not to detain you too long, but there are a couple of questions that the GWC would like assistance with, if you can, and which may be of assistance to the commissioners. Now, you will recall that you presented to the Gaming and Wagering Commission for the first time on the 15th of December 2020. Is that correct?
That's correct.
And you presented for a second time in February 2021. And the purpose of both of those presentations was to introduce yourself to the Gaming and Wagering Commission, first as you were then chair of CRL and later as executive chair of CRL, and to provide some assurance to the Gaming and Wagering Commission as to CRL's intentions.
Yes, if I may explain, I wish to do this as I approached the regulators in each jurisdiction as a matter of courtesy and to assure the West Australian regulator and the Victorian regulator that Crown, through its board at least and senior management, didn't have a tin ear. We'd listened to the Bergen evidence. I had in train a major program of rectification, and it was my view that it would be relevant to each of the regulators in each of the jurisdictions to understand the way in which we were trying to remediate the company. So that was my first intent.
And in addressing the question of remediation, obviously one has to address what is to be remediated, doesn't one?
Well, that's what the remediation program did, yes.
And one recognises that in dealing with a regulator in those circumstances, there is a need for a very high level of candour if one is to be believed in relation to the representations that you're making.
Well, yes, if you're making representations, certainly.
Yes. And one of the issues which was live from the Bergen inquiry at that stage was the possibility of money laundering through what are called colloquially the South Bank and Riverbank accounts. Is that right?
Yes.
And it's the case, isn't it, that about a month prior to your first presentation to the GWC, Crown had obtained from its consultants Grant Thornton and Initialism reports which contained relatively unequivocal indicia of money laundering through those accounts.
Well, the reports showed that. I'm not sure when Crown got them. I know that they were given to the regulator at about the time of my meeting. I had no line of sight into when that was.
We'll come to that, Ms. Kernan, in a moment.
Okay, all right.
My question for you is, when were you first made aware of the contents of those reports? Not necessarily given the reports, but made aware of the contents of them.
I'm just not sure. I couldn't put a date on it.
Was it prior to your first presentation to the GWC?
It may have been, but they may have been drafts. And my recollection, I think, now is that Crown was looking at the reports and looking at whether there'd be some response to them.
Response to your own consultants?
I don't know when I was aware of the contents.
For the purpose of making your presentation, you were provided with some briefing notes. Do you recall those?
Yes, I had some briefing notes from Chris Riley.
And who's Mr. Riley?
Mr. Riley works in Melbourne, actually, but as I understood it, he had set up the meeting through someone in Perth.
And that meeting had been set up at your request, however?
Yes, I mean, I wanted to introduce myself.
And that meeting was conducted by yourself and Mr. Barton principally, as I understand it?
Yes, yes,
You've read those briefing notes?
yes.
Can I bring up those briefing notes just to remind you, in case you're not familiar with all of them, with the full content of them? Now, CRW.513.021.3859. You recognise those?
Yes,
Can I just, if the operator can just scroll briefly down, so you'll see that there was a provision for you to thank the GWC for its cooperation to date and to make some promises or assurances about the future. And I know, if I can take you to the paragraph starting importantly, you want to assure that Crown Perth will remain in full control of operational matters. Now, can I just say there, this was a presentation on behalf of the Crown Group collectively, is that right?
no, it was really me as chair, just reaching out so they had a name and a face and someone who they could contact.
Well, you're making representations on behalf of Crown Perth there as to what Crown Perth is going to do.
Well, what that related to was the proposal in relation to a potential restructure that had been mooted of that we'd had some advice about, I think from Herbert Smith Freehill, which related to potentially how the subsidiaries might be restructured. It's now, I mean, it's just parked. It's not something that's likely to proceed anytime soon, but that's what that referred to.
But the GWC wasn't briefed about that potential restructure as part of this presentation, was it?
I'm not sure.
It doesn't form part of the briefing notes.
No, it doesn't form part of the briefing notes, but I understood that management had a prior meeting. I think Mr. Barton had had a meeting, and I understood that he may have given at that presentation an outline of a potential restructure.
That's Mr. Barton's
And Mr. Riley might have picked that up.
That's Mr. Barton's meeting in October of 2019. Is that correct?
It might have been. I mean, I wasn't there,
2020.
but I have since seen a presentation, and I have a feeling that it might have been a reference to the mooted restructure.
Did you read through the entirety of these notes at the time they were given to you?
I may have. I think I did, yes.
Yeah. So you'd have read the section which is attributed to Mr. Barton and which he spoke to?
You'll have to show me.
Can you, the operator, roll down, please, to the second page? I think it is. The heading, Ken Barton.
Yes. Yes, I remember all that.
And you see in there reference to the Riverbank Investments bank account being closed?
Yes.
Now, were you aware at that time that the Initialism and Grant Thornton reports had been delivered to GWC?
I just can't say yes. I may have been aware, but I don't know.
You were aware, you can see that you may well have been aware, likely I would have to suggest were aware of the fact that those reports had been received.
I don't know. I mean, I would tell you if I had a recollection of when I received it, but I don't.
Well, the proposition I want to put to you is this, Ms. Kernan, you as chair, were deeply concerned in the progress of the inquiries then being conducted by Commissioner Bergen in New South Wales.
Yes.
And very late in the course of this inquiry, these reports had been disclosed to Commissioner Bergen. You were aware?
I'm not sure. No, I don't.
You have no
I don't know.
recollection of that?
I don't know when they were given to Commissioner Bergen. What I recall was that right at the heel of the hunt, I think about the last day of evidence, there was some other information that had come to light that Grant Thornton were engaged in relation to those matters, but I'm not sure when any of the reports were received, certainly not by me. Or when they went to Commissioner Bergen.
So you're not...
Because the evidence closed and I just cannot recall when I got them. I mean, of course I know what they say, and I'm well aware of them now, but I just don't know when the date at which I got them.
Well, let's postulate this. If you had received that information prior to the 15th of December, would you have regarded the information in those reports as being essential to be promptly disclosed to the GWC?
Yes.
Thank you. Now, can I take you to another topic which, again, relates to the broad sweep of the regulatory investigations which Crown has been facing over the last 2 years or so. In your witness statement, you say that Crown has ceased dealing with junkets and junket operators. That's in your witness statement at 48J. You recall that?
Yes, I do.
Now, earlier this afternoon, you gave evidence that is now an absolute commitment or a determination not to deal with junket operators. Was that, you recall that was your evidence?
Yes.
Now, Crown, you understand that Crown previously lobbied for the elimination of state licensing of junket operators, and that only Queensland maintains a licensing system in relation to junket operators today?
I'm aware of the latter part of your question.
You weren't aware of that it was Crown that actively lobbied state regulators in Western Australia and Victoria for the elimination of...
Well, I wasn't involved in it, and I don't know that.
You don't know that, all right. Is it then the case that the CRL position has moved further from the position which was stated as at 14 December 2020 by Mr Barton in his letter to the Gaming and Wagering Commission? You recall that that letter exists? That's the letter which was provided to GWC the night before your presentation on the 15th?
Could I see it, please?
Yes, can you bring up CRW.513.021.6266?
What am I looking at, Mr Wood? I'm sorry. I've got it one page.
Yeah, Mr Evans, and it's before
Oh, sorry, now it's my turn. Sorry.
there are too many parties. Can you roll back up 4 pages, I think it is, to the beginning of that document? Operator, thank you. Now, this is the letter which was sent to Mr Ord as Chair of GWC and also Director General of the Department on the 14th of December 2020.
I can see that.
Did you see that document before it was sent?
No.
Did you read it prior to your meeting on the 15th of December?
I don't believe so.
Have you subsequently read it?
Yes.
On the 4th page of that letter, at point E, this is in an annexure to the letter in fact, it's represented that Crown has permanently ceased dealing with all junket operators subject to consultation with gaming regulators in Victoria, Western Australia and New South Wales. Crown will only recommence dealing with a junket operator if that junket operator is licensed or otherwise approved or sanctioned by all gaming regulators in the states in which Crown operates. You understand that?
Yes, I do.
Did that represent the position that Crown Resorts Limited had resolved at that time?
It went through about 3 iterations. What this actually refers to is the fact that under some clauses of the agreement, there's certainly in Melbourne, there was an obligation to maintain Crown as the premium commission-based casino. And there may be similar, I don't know whether or not there's a similar arrangement in or requirement in the agreements with Western Australia. The board was concerned that we should consult first, but I think events simply overtook us. And the board's very firm view is that the risks are unacceptable in dealing with junkets, and the resolution is that we will stop dealing with junkets. And as you know now, there's some regulatory intervention to require that.
That's certainly the case in Western Australia. There's a direction has been given to that effect.
Yes.
Although it's not an unconditional direction in the light of this representation. Now, I'll repeat my question. Is it now CRL's position unconditionally that it will not deal with junket operators in the future?
Yes.
And I asked that question because I did notice in the Burswood Limited board papers for the I think it's the June board meeting, that there are renovations planned to the Pearl Room in Perth. Now, you understand what the Pearl Room is?
Yes, sorry, you just cut out there for a second.
So I understand from those papers that there are renovations contemplated at some considerable cost to the Pearl Room in Perth.
Yes,
The Pearl Room is the equivalent of the Mahogany Room in Melbourne.
yes, yes,
It is a venue which has historically, since its inception, been reserved for high roller gamblers in those casinos,
yes,
principally junket gamblers.
yes.
And I was left wondering why such expensive renovations were contemplated to the Pearl Room if junket gambling was no longer to be contemplated in those casinos.
Well, local premium play is obviously the way in which we have to restructure our business.
Right. So the evidence before the commissioners today is that Crown Resorts eschews international commission business by way of junket operations now and into the future.
Yes,
And it does not seek to have a new regulatory regime erected under which state regulators will reassume a role of licensing junket operators.
it certainly does not seek that.
Thank you. Can I then go to the topic of continuity and refreshment in the Crown Resorts Limited Board? Now, you've referred in Witness Statement 42 to appointments made to the CRL Board in recent times,
Yes,
and in particular referred to the appointment of Mr Morrison, the former CEO of Sky City, and Mr Bruce Carter, the former Deputy Chair of Sky City, in January and April 2021 respectively.
yes.
Are they the only appointments which have been made?
Apart from Mr McCann, the CEO, who will also be a director.
So do we take it from those two appointments? No,
Three.
sorry, those three appointments, I'm putting Mr McCann to one side. And to understand, Sky City is a public listed casino operator which operates casinos, I think, in New Zealand, Adelaide, Queensland, possibly Tasmania. Is that right?
Not sure about Tasmania, but certainly the other jurisdictions.
Yes. Do we take it from that you consider the future success of CRL and its group is dependent upon gaming industry expertise at the highest levels of the company?
Well, we did think that it was a relevant skill set to have in some new appointments.
And the first and second appointments of independent, non-executive directors are both people with a strong history in the listed casino industry,
Yes,
both from the same company.
yes.
And before doing that, was due diligence done on Sky City and its history of involvement in relation to issues which are the subject of the various inquiries in which Crown Resorts is concerned?
There was extensive due diligence done at the time, both externally. Both of the candidates were validated. Mr. Morrison has received probity in this jurisdiction, in Sydney and in Melbourne. Mr. Carter, I think, is waiting in New South Wales, but otherwise has received probity, which fortifies my view and the inquiries we made that they are appropriate appointments.
Was it of concern that Sky City had previously engaged with junket operators in the conduct of its own operations?
It's always of concern if there's allegations of money laundering.
Well, no, not money laundering. Was it of concern that Sky City had engaged with junket operators in the course of conducting its business?
Not at the time.
Although junket operators were a prime subject of the inquiries which Crown Resorts was facing.
Just let me track back a little bit. Would you just mind asking again?
So was it of concern to Crown Resorts Limited that Sky City had a history of contracting with junket operators for international commission business?
Not of major concern once these people received probity.
Was it of concern that Sky City might be facing allegations of contraventions of the AML-CTF legislation?
Well, it's potentially any casino operator, any bank, any financial service provider can be subject to allegations.
Indeed, Sky City self-reported that on the 7th of June, on or about the 7th of June 2021, that it was a subject of an Australian inquiry in relation to those matters. Was it of, you are aware that one of the subjects of inquiry, in particular in the Melbourne Royal Commission, is the ability of Crown Melbourne, and although it was not apparently used, Crown Perth, to accept China Unipay payments
Yes.
of gaming at the casino.
Yes.
Was it of concern that Sky City accepts China Unipay cards in its?
I'm not aware of that.
All right, we'll move off that to be not aware of that. Now, we accept that you've had a torrid time between the Ilga Bergen inquiry, Austrac inquiries, ASIC inquiries, the Melbourne Commission, and now the Perth Casino Commission.
That's very kind of you, thank you.
Each of those necessarily poses a significant business risk for Crown Resorts, does it not?
Of course.
And you've been very closely involved because you've given evidence in both the Ilga inquiry and the Melbourne Royal Commission inquiry.
Yes, this is, I've now got the triumvirate 3 times.
And you necessarily have been closely involved in the direction of Crown Resorts' response to those inquiries, in particular over the last few months.
Yes, I think in response, it's certainly in respect of Victoria.
I would assume in doing that you have sought and obtained the support and approval of the board for key decisions in relation to the conduct of the proceedings before those inquiries?
Yes.
And you say in your statement that Crown has accepted the deficiencies in its culture and its governance and risk processes and frameworks contributing to and underpinning several of the findings made in the Bergen report. That's your witness statement at 35.
Yes. Yes.
And you understand that those deficiencies are such that the Bergen inquiry found that in answer to the question whether the licensee, that's the Sydney Proprietary Limited licensee of the limited casino licence in New South Wales, as to whether it was a suitable person to continue to give effect to the Barangaroo restricted gaming licence, the answer of Commissioner Bergen was no.
Yes, I've accepted that. I agree.
And that Crown, and as to the question of whether Crown Resorts Limited was a suitable person to be a close associate of that licensee, Commissioner Bergen answered that question no.
Yes.
And 9 days ago, Crown made closing submissions before the Melbourne Royal Commission.
Yes.
Mr. Borski QC made those submissions orally on behalf of Crown.
I think they were in writing as well.
They are in writing. Yes, I have yet to have the luxury of being able to attain the written submissions, but I have the transcript of the oral submissions. Now, those submissions were obviously approved by Crown Resorts Limited before they were made.
Yes.
And by you personally?
Well, I was part of the board examination of the submissions.
Yes. And those submissions included the following, and the relevant document, Commissioners, is com.0040.0040.0001. And I'll just give you the transcript references. Mr. Borski submitted that from the outset of this Royal Commission, Crown has adopted a different approach to it as compared to the one adopted in the Bergen inquiry.
I've only got the cover page.
So can we go to page 4052 of the transcript? I don't have the pinpoint.
Oh no, it's the transcript page.
That's 4094.
I think it's internal number.
There we go.
So about 1034.35, which is towards the lower third of the page.
From the outset, Crown is, yes, I've got that.
That's right.
Um,
And just to understand what that different approach is, the approach to the Bergen inquiry has to be characterised as being somewhat combative and defensive, does it not?
I think that's a fair characterisation.
Mr. Borski then says, you, referring to the Commissioner Finkelstein, wrote to directors of Crown on 10 March asking whether Crown accepted that it was open to Commissioner Bergen to make the principal findings that she made and to conclude that Crown was not suitable. And
Is that on the next page?
it is on 1034.39. It's a balance of that paragraph from the outset of this Royal Commission. Bottom third of the page.
Yeah, thank you, yes.
And then to move,
Yes, that's correct.
and to move to the next paragraph, Crown, in its response 7 days later, it goes without saying that was authorised by the Board of Crown, accepted that it was open to make the findings I've just taken you to.
That's absolutely correct.
And also accepted the essence of the Commissioner Bergen's 3 principal findings on the factual areas of inquiry, the subject, which supported those conclusions.
Yes.
Now I'm going to roll down 2 pages to 4054. And at pinpoint 1037.31, which might be the next previous page perhaps. I might be working on a slightly different version. 1037.31.
I've got more generally on instructions from Crown. There's been close cooperation. That's 28?
Yes, no.
37.
Can you roll up slightly? Operator?
And then you go into China Union Pay.
No, can you roll up slightly further? I may have, unfortunately, we may have loaded up a slightly differently numbered version. Now, can you roll up to 10 to 4052? No, sorry, no, that's not right. This is supposed to be a timed transcript. Can you roll up to 4052 again? I'm struggling to find the transcript reference. Ms. Kuhn, and I apologise for delaying you in that regard. But can I put this proposition to you because you will recall it, I am sure. That Crown accepted on the evidence before the Melbourne Commission that it was open for the Commissioner to conclude, although this was not its primary contention, that it was open for the Commission to conclude on all the evidence that Crown Melbourne was not a suitable person to continue to hold the Crown Melbourne casino licence.
Yes.
You recall that?
Yes.
And that was a considered position that Crown Resorts had reached.
Yes, it was all considered.
That remains the position.
My understanding is it does.
And it's a position which you have endorsed.
Well, the board endorsed it.
And you as a member of the board so endorsed it.
Well, as all the members of the board endorsed it. There were no dissenting.
Thank you. No further questions. Thank you, Commissioners.
Thank you, Mr. Evans. How long do you think you'll be, Mr.
perhaps 5 or 10 minutes.
Ms. Coonan, I'm conscious that it's been an hour and a half or so.
There's someone else who also wishes to intervene, I think.
Before you, or?
Yes, before me, I think.
Okay, well, I'll just ask Ms. Coonan. We are absolutely determined to finish today, but if you would like a break, we can take a short break, or we can keep going.
I think we can keep going. If you just excuse me, I need to just retrieve my glass that wandered up the table here. I'll refresh myself and I'm ready to go.
So,
I'll cede to Ms. Shepherd.
yeah, Ms. Shepherd is.
Commissioner, I seek leave to examine Ms. Coonan with respect to paragraph 11 of her statement. I shouldn't be more than 5 minutes.
Go ahead.
Thank you, Commissioners. Ms. Coonan, my name is Shepherd and I appear for Mr. Barry Felsted.
Yes.
Earlier, you gave evidence that you were aware that up until April 2017, the group CEO was Rowan Craigie. That's the case, isn't it?
Yes.
And from 2017 to 2020, Mr. John Alexander assumed the responsibilities for group CEO, didn't he?
Yes, he did. He was the executive chair.
Executive chair and group CEO?
Yes, both.
And from 2020 into 2021, the group CEO was Mr. Ken Barton. That's the case, isn't it?
Yes.
And it's never the case that Mr. Felsted has ever occupied the role of group CEO, has he?
Not that I'm aware of.
No. Do you recall Ms. Cahill took you to a CEO report from 2013 in the course of questioning?
Yes.
And do you recall you agreed that it was typical of the CEO reports presented to the Crown Resorts Board, and that particular report you said had been authored by Mr. Craigie? Do you recall that evidence?
I think so. I mean, I only had a bit of the document shown to me, so I think it was Mr. Craigie.
Yes, because he was the group CEO at the time that that report was presented, wasn't he?
Yes, I think that's correct.
And that reflects the
I
usual...
was hesitating because I just didn't have the whole document and I thought it was Mr. Craigie.
Certainly, and that reflects the usual practice, doesn't it, that the group CEO is the formal author of the CEO report that goes to the Crown Resorts Board at any point in time, doesn't it?
Yes.
Yes, and that is notwithstanding that management might also have input into that report.
I think that's right, and even give parts of reports.
Certainly. Can I ask that the operator bring up, just to the council screens, the following document, CRL.506.007.7878. This is the Crown Resorts Board Pack from the 19th of February 2019. Do you see that?
Yes.
And can I ask that the operator turn to page ending 7879? And do you see there the agenda, including item 4 is CEO's report?
Yes.
Can the operator please turn to 7907? And you see there the document is headed Crown Resorts Limited Chief Executive Officer's Report. Do you see that?
Yes.
And that suggests the formal author is the CEO of the Crown Resorts Board, doesn't it?
Yes, yeah. Given under his authority anyway.
Yes, and at that time that was Mr. John Alexander, to your recollection?
Yes, that's true.
Can I ask that the operator please turn to page ending 7884? And do you see here the draft minutes for the previous meeting being at the 11th of December 2018?
Yes.
And do you see there that you're an attendee?
Yes.
And also in attendance are Mr. John Alexander and also Mr. John Poynton?
Yes.
And you recall that they were directors also of Burswood Limited at the time?
I think that's right, but I just not sure.
And do you see there by invitation, there's Mr. Ken Barton, Mr. Felsted and Mr. Preston?
Yes.
Could I ask the operator to turn to page ending 7885? And you see that there's a trading update. And speaking to the trading updates, Mr. John Alexander and Mr. Ken Barton, as well as Mr. Felsted. Do you see that?
Yes, I do.
And specifically, Mr. Barton is speaking to the trading results for Crown Melbourne and Crown Perth. Do you see that?
Yes.
Being the operating entities or the operating businesses of the subsidiaries.
Yes.
And Mr. Felsted is also speaking to those matters, but he's not speaking exclusively to those businesses, is he?
No, and he usually spoke. No, that's right.
Yeah. And can I ask the operator now to turn to page ending 7887? Right at the bottom at about point 8 of the page, you'll see an item headed VCGLR recommendation update.
Yes.
And Mr. Preston is presenting on that particular item, isn't he?
Yes.
And that's a regulatory update specifically with relevance to Crown Melbourne, isn't it?
Yes.
Yeah. Can I ask the operator to turn to page ending 7891? Do you see that draft minutes are
Yes.
tabled for the Risk Management Committee and also for the Responsible Gambling Committees?
Yes.
And that was the usual practice, wasn't it, for Crown Resorts board meetings?
Yes.
And the Risk Management Committee minutes reflected contributions from the ERCC in Crown Perth and the Audit and Risk Committee from the relevant properties. Do you recall that?
Yes, that's right. I was never on that committee, but that's my understanding.
And certainly the Responsible Gambling Committee minutes reflected operations of Crown Melbourne and Crown Perth as they related to responsible gambling issues. Do you agree with that?
Yes, that's true.
Can I ask the operator now to turn to paragraph 11 of your statement, which is at page ending 0181, and if that can be highlighted. Can I ask you now to look at the first sentence of that paragraph?
Yes.
Ms. Coonan, I suggest to you that that first paragraph is wrong, and it's wrong in two respects, which I now invite you to reconsider. The first respect in which it is wrong is that Mr. Felsted was not the group CEO at any point in time, was he?
That's absolutely right. That should be corrected.
And the second aspect, which I invite you to reconsider, which is that reporting in relation to the subsidiary properties was not limited to the reports provided by Mr. Felsted, was it?
I'm sorry, you've lost me there. Could you just go again?
You've said in the first sentence of that paragraph, which is that reporting in relation to the subsidiary properties.
Yes, I've agreed with that. I've agreed with that. It was the next part of your question.
Yeah. No, that you've agreed with the proposition that Mr. Felsted was not the group CEO.
Yes, he was the Australian Resorts CEO.
That's right. And any reporting given by Mr. Felsted was not the only means by which you were informed about the subsidiary properties.
That's true. That's true.
And so to the extent that you suggest that reporting in relation to subsidiary properties was limited to reports given by Mr. Felsted, this commission should reject that evidence, shouldn't it?
Well, I hope they'll accept my sincere apologies to Mr. Felsted and correct it in the way in which we've just done.
Thank you, Ms. Coonan. I appreciate that reconsideration. Commissioners, there's no further questions.
Thank you, Ms. Shepherd. Mr. Damananda.
Yes, thank you. Ms. Coonan, it's late over there. I'll try to be brief. Mr. Evans asked a few questions about the work done to the Pearl Room. Do you recall that?
Yes.
You're also aware, aren't you, that there was an ASX release on the 5th of March concerning the phasing out of smoking in relation to the Crown Perth Casino, And is it the case that the changes to the Pearl Room are made to effect this change in policy?
Yes, it was to provide some reconfiguration that will allow the anti-smoking policy to be implemented.
Thank you. Mr. Evans also asked you about submissions made to the Finkelstein Royal Commission by Mr. Borski with respect to a position that was said to be open about Crown not being suitable. Do you recall that?
Yes, I do.
And that was very much not the primary contention advanced by Crown in respect of the Crown Melbourne Royal Commission, correct?
That's right.
You were asked some questions by counsel assisting concerning who was to replace Mr. Stokes. Do you recall that?
Yes.
If you turn to paragraph 48A of your witness statement, you'll see there's a reference to a new department as well as a number of new persons that have been appointed to it. If you go over the page, please, operator. There's a reference there to Armina Antonio. Do you see that?
Yes, that was the person's name. I couldn't remember. Sorry.
No, not at all. Then there were some questions directed to the ERCC and its lines of reporting. Do you recall that, Ms. Coonan?
Yes. Yes.
You explained how there were 3 lines of defence with respect to the structure concerning attending to risk matters within the Crown Group. You recall that?
Yes, I do.
And if I could take you, please, to CRW.516.009.6888. That is a representation of the lines of reporting, and does that accord with your understanding as to how there is to be reporting insofar as the work of the ERCC is concerned, Ms. Coonan?
Yes, it's now been standardised across the properties, so that is in accordance with my understanding.
In the course of your evidence this morning, you were asked questions about your intentions and whether you intended to take on any other role with the Crown Group. Do you recall that, Ms. Coonan?
Yes, I do.
And it's clear, isn't it, that you do not intend at any stage to be on the board of Crown going into the future, whatever else you might be called upon to do?
Yes, I have no intention of any role, but certainly not on a board.
Thank you. With your imminent departure, can you comment succinctly for the benefit of the commissioners the tasks that you saw as priority tasks in the intense period after the Bergen inquiry report?
Yes, yes. After the Bergen report, the company was in turmoil, and in very short order, we lost almost all the board. We lost our CEO, or our CEO stepped down. Senior management left, and we were literally scrambling to be able to run the company in the light of the fact that we also had, in very short order, 2 royal commissions to be dealing with. We had regulatory issues to do with AUSTRAC. We had class actions. We had ASIC. On top of that, as well as trying to just run the business and stabilise the business, it was necessary to set about repopulating the board. And you could appreciate that in the circumstances, it hasn't been an easy task to attract capable and qualified people to take up these positions. We have 2 very good directors and some more in prospect. We've got to a point where together with my directors, I believe we've identified a very good chair to replace me, subject to probity. Those discussions are well advanced, but in very short order, it was necessary to set about recruiting, vetting, and onboarding a new CEO. That is a major, major task in a publicly listed company. We've had to comply with almost daily disclosure obligations in respect of market updates. It's been necessary to deal quite understandably with investors and other stakeholders and to have many, many meetings. And then to deal particularly with the New South Wales regulator in terms of embedding the rectification program that we started last year, but which has obviously escalated and is now populated with new management and people who can give effect to the major reforms that we've now introduced to the company. It is a different company with a different culture, a different risk appetite, very advanced, I think, new AML capability, proper structural reform, and capable people across the organisation to give effect to it if we're privileged enough to be able to operate our licences in each of our jurisdictions.
Thank you.
And also, I do hope, although there may have been a few setbacks along the way, that we've had an opportunity to reset the relationship with each of the regulators. This is the way Crown intends to go on. I'm not so naive as to think that there won't be setbacks here and there across various matters, but we are a new open and transparent organisation, a clean and ethical operation, and that's the way we intend to go on.
Thank you, Ms. Coonan. Nothing further, Commissioner.
Thank you, Mr. Nanda. Are there any other applications? No, thank you. Commissioner Murphy?
No.
Thank you. I have just two short questions for you, and
Yes, Commissioner.
both of them by way of clarification. In paragraph 49 of your statement, you refer to the remediation plan. You don't need to bring it up. You refer to the remediation plan at the 30th of July of this year.
Yes.
In item 5, which is on the 4th page, there's a heading governance structure. And in answer to some questions from, it might have been Mr. Evans, I'm not sure, you referred to that and said that advice was being sought from Herbert Smith Freehills on the governance structure, and you referred within that to the corporate structure itself, the subsidiaries, and I took that to mean the identity of companies within the group. And you said something to the effect that that hasn't progressed. I just wanted to know whether that was still part of the work and that part of the plan on which Herbert Smith Freehills are advising, or whether that's gone away. That second aspect of it, the corporate structure.
Yes, I think it's struck a few shoals, if I could put it that way, Commissioner. It received an enthusiastic reception in New South Wales, less so in Victoria and WA. And I can say that it has been brought to my attention by both by commissioners in both WA and in Victoria that that's not looked upon favourably. It may require legislative changes anyway, what we had in mind, or other regulatory intervention to enable it to happen. So I think the best way to describe it is it's got a placeholder and no present intention to proceed.
All right, thank you. And my other question is one that, just to return to something that I asked you before. It's about paragraph 76 of your statement, where you referred to soon to be Mr. McCann. You remember?
Yes. Yes.
I just want to make sure that I understand this. In answer to a question, in answer to that question, you said that it was the intention to have Mr. McCann, subject to probity checks, added to the board as managing director. That's right, isn't it? And then in answer to a question from Mr. Dharmananda, you said that the selection of a new chair of the board was also a matter that was under serious consideration, subject to regulatory approvals.
Yes.
I just want to understand whether there is any present contemplation that Mr. McCann might replace you as executive chairman.
No, that's not in contemplation, and the thinking of the board around my replacement is an entirely individually different person, someone of significant experience in chairing publicly listed companies. So Mr. McCann is not mooted, nor would he accept, I don't think, that role, nor would he be offered it.
Thank you very much. Thank you.
Thank you.
Jenkins?
Lastly, Ms Coonan, I'll try and...
Commissioner Jenkins, I would have been disappointed if you hadn't had some questions.
That's what's motivated me. No, look, on a more serious note, you've been examined today about a number of issues relating to the Burswood entities, which of course is the focus of our investigation, our inquiry.
Yes.
And those matters have included matters such as the fact that the composition of the boards of the Burswood entities is not stable at this time. You'd agree with that?
I'd absolutely agree with that. I apologise that we just haven't been able to turn our mind to it to do that, but it's certainly in prospect. I can assure you of that.
Well, that's really what I wanted to focus on, and just let me mention a few other matters. Would you agree? You've also acknowledged the fact that the Burswood Limited has no charter.
Yes, that's true.
It also has no subcommittees.
Yes, that's right.
Ms Fuster's given evidence that she's not seen any KPIs that the board has set for either its own performance or indeed for the Perth Casino's performance. Would you agree that those are matters that you would expect Burswood Limited as overseeing the Perth Casino to attend to?
Yes, I think all of those matters need attention.
And those matters probably have not been attended to date because of what you would see as the more pressing matters at Crown Resorts level, and also in terms of the management of the various properties.
Yes, I think managing people in and out and getting people to populate positions has been critical, together with responding to the Royal Commissions quite appropriately. But there is some advanced thinking around how that might be approached. So I wouldn't want to leave you, Commissioner, with the impression that it's just been put to one side as not important. It hasn't taken number one priority for those reasons, but it will deserve appropriate attention.
So those matters that I have mentioned, what do you see as the time frame for those matters being attended to at the Burswood entity level?
It's really difficult because it involves more people. As I've explained, it is difficult to get people who are comfortable with coming onto any of the board or subsidiaries of Crown at the moment, although there are people who are interested in the challenge. So there's a couple of people who are in prospect here. That is, when I say here, sorry, in Western Australia. So it's really a matter of doing all the due diligence and then them getting probity, which, as I say, can take some weeks unless regulators can expedite it.
Now, I want to ask you a couple of questions about regulatory framework. You would be aware that in Victoria, the Casino Control Act requires the Victorian regulator to undertake regular investigations of the casino licence and operator at intervals not exceeding 5 years. And you would have been on the board of CRL for at least 2 of those inquiries. Board?
Yes, the 5th and 6th, I think.
And whereas in Western Australia, no such reviews are required.
No.
Do you have a view as to whether that requirement is beneficial for the proper regulation of a casino licence and its operation?
Yes, I agree with that. And I think that the fact that it doesn't exist in Western Australia really probably left the government with little choice having regard to the Bergen matter other than to have a royal commission. In Victoria, it was contemplated that the 7th review would be brought forward instead of a royal commission, and they were last to the table with a royal commission. But I understand the position in WA was that wasn't an option available, and I think it should be.
Now, Ms. Coonan, do you have other views about what is the appropriate statutory regulation for a casino in Australia and in particular Western Australia?
I'm of the view, and this is probably not a popular view given how important it is to a state how a licence for a casino is regulated, but I do think that having some uniform regulation of casinos might not be a bad idea, but I haven't really formed a concluded view about it. That's just an off the top of my head thought.
It's just that you have been obviously in director of CRL now for a considerable period of time, but you are soon to depart, it seems, so that if you had any particular views about that issue, this might be your only opportunity to express them. Is there any other view you have about casino regulation that you wanted to express?
I do endorse the views of Commissioner Bergen. I think that much greater cooperation between regulators and AUSTRAC, better flow of information is a very good thing. There are some real difficulties in observing the tipping off provisions and telling regulators certain information. I know that exercised some of management during the course of my time on Crown Board. That was difficult. But the actual, structure of it, I mean, I think requiring the regulator to for example, to licence junkets is really not a good idea, not that they will. I think junkets have gone to God, and I think that that's probably the best thing in terms of risk management going forward.
Just finally, to clarify your answers, do I understand you to say that the CRL board would have permitted Mr. Barton to remain with CRL if he had not himself wanted to leave and ILGA had not wanted him to leave?
No, that's not what I meant. I meant that it was mutually agreed, and the matters referred to in Bergen did have an impact and were relevant to Crown's decision. But in the context of the agreement with Mr. Barton, what I was seeking to do was to put it in a broader context in relation to ongoing need to be able to access Mr. Barton.
And what about in respect of Mr. Felsted and Mr. Preston? Do I understand or misunderstand, I'll put it in positive, do I understand you to say that the CRL board would have permitted them to stay if there'd not been a restructure?
No, the CRL board would not have. There was some disagreement on the board as to separating from Mr. Barton and Mr. Preston, but ultimately there was a consensus that it was appropriate for them to be separated. So that was also, I think, a redundancy in form that Mr. Barton then executed.
Thank you. Those were my questions.
Anything arising?
Thank you. Ms Kernan, you've had a long day. I want to take you back to the very first question that you were asked by Councillor Assisting Ms Cahill this morning. If you can think back that far, and it relates to a question from Commissioner Owen. If you can go to your operator, go to the witness statement at paragraph 7. And this relates to your intention and your statement in paragraph 7 as to your intention in regard to your roles. And Councillor Assisting referred to the statement in the second last sentence that you expect to appoint the new leader, that's the new CEO, by 31 August 2021. And then the next sentence says, in the interim, I will continue to assist with the Crown reform programs to the best of your abilities. When you said to Councillor Assisting Ms Cahill that you would be stepping down on 31 August 2021, is that only in your capacity as the Executive Chair?
No, I'll just clarify. Thank you for the question. There's no set date for me to go. The current thinking is that it will be by the 31st of August 2021, but currently there's no date. That's important. I think that we first of all understand that. Secondly, the new leader is to be the chair, not the CEO, so there's a distinction there. And I won't be continuing to assist Crown's reform programs beyond when I leave sometime this month.
So, and Commissioner Owen asked you about the new chair. Is that also imminent? Is it?
Yes, the announcement is imminent, but different from Mr McCann, who's been announced and working since the 1st of June.
And you've said a lot today and answered many questions. Is there anything further you would like to tell the Commission or advise the Commission which may be of assistance to them in this inquiry?
I've had a long period of involvement with Crown, and I'm deeply sorry that some of the matters that have emerged in relation to matters before this Commission and others have occurred. My role in continuing on the board since the Bergen inquiry has been very much an interim one, always intended to be interim, and having given Commissioner Bergen an assurance that I would stay the course, at least in the short term, to steady the ship, so to speak, that's what I've done, and I'm extremely proud of what we've been able to achieve in a very short time. There's certainly much more to go, but I would like to very much thank the Commission for listening to me today, and I'm sorry it's been such a long day for everybody, but I do hope that I've been of assistance.
Thank you, Commissioner.
Ms Kernan, we're very conscious of the many calls on your time at the moment, and are grateful to you for making yourself available and for your evidence, which has helped us. In case there's some tidying up to do, we'll leave the summons in place, but you're free to go, and thank you very much. Thank you.
Thank you, Commissioners.
Commissioner, I just rise to ensure that, as required, we may be able to speak with Ms Kernan.
Yes.
Thank you.
That's appropriate. Now, someone's going to have to help me. When do I adjourn to?
Tuesday at 10. Oh, no, it's Wednesday.
Wednesday.
10 a.m.
Thank you all. Thank you all. We will adjourn and resume at 10 a.m. on next Wednesday. Thank you.
Thank you.